Northlands Media PR and Marketing Limited presents the Global IP Magazine Issue 25. GIP Magazine 25, front cover text. Till death do us part, the effect of death on trademarks. The role of IP rights in the sports sector. Skating on thin ice, patent renewals and the cost of a miss. The onus of claim mapping, a serious task. Plus much more inside. Welcome to London INTA. Main front cover heading. Hybrid Intelligence, moving from AI-assisted to AI-architected IP portfolios. Dr. Shweta Singh, founder and CEO of Ennoble IP, India. Front cover strip advertisement. Pat World. Global Intellectual Property and Research Services. www.patworld.com, mail at patworld.com, telephone, +44 01633 816 601.
Page 2. Inside front cover advertisement. IP Tech and Innovation Services Annual. Recognizing the game changers redefining innovation and driving support across the world of intellectual property. Showcase your IP tech innovations to a global audience in the 2027 edition. The global platform for IP technology and service providers. Whether you're offering solutions or seeking them, join the publication that connects innovators, law firms, and corporates worldwide. Feature your profile, share your expert editorial, showcase your platform's capabilities, and enhance your brand visibility in the IP Tech and Innovation Services Annual 2027. Contact us today at +44 2038130457. Technovation@northonsprmarketing.com. www.iptechnovation.com.
Page 3. Editor's Note. Dear readers, we are pleased to present the INTA Special Edition of the Global IP Magazine, Issue 25, launched alongside the International Trademark Association, INTA, annual meeting in London. This edition reflects the evolving role of IP in shaping innovation and commercial strategy, where it is no longer seen solely as a legal safeguard but as a key driver of growth, competitiveness, and long-term value. In this issue, we bring together a range of perspectives from professionals working at the forefront of the field. Their contributions reflect the realities of managing IP in a world shaped by rapid technological advancement, shifting regulatory environments, and increasing global interconnectivity. From developments in artificial intelligence and data-driven decision-making to practical insights on enforcement and portfolio management, the content within these pages is both timely and grounded in real-world experience. We begin with Ms. Shweta Singh, founder of Ennoble IP, India, who explores the evolution of IP from AI-assisted workflows to AI-architected, hybrid intelligence portfolios that integrate real-time business, market, and competitive insights. She highlights how AI is shaping strategic decisions, enabling proactive portfolio management, improved efficiency, and predictive protection planning, while emphasizing the importance of balancing machine intelligence with human judgment. From there, we move to Michelle S. Katz, founding partner at Advitum IP, LLC, USA, who examines how trademarks are treated as valuable estate assets and the legal processes governing their transfer after death. She clarifies how ownership passes through wills or intestacy laws, which require formal assignment and registration, and highlights the importance of estate planning in preserving brand legacy and commercial value. We then turn to Anomi Wanigasekara and Sabira Sharif of Julius & Creasy, Sri Lanka, who discuss the integral role of IP in the sports industry, outlining how trademarks, patents, designs, and copyright support commercialization, innovation, and brand protection. They also address key challenges such as piracy and ambush marketing, emphasizing the need to balance protection with industry integrity as the sector continues to evolve. Beyond these articles, this special edition also offers a wealth of thought-provoking discussions that further illuminate the evolving dynamics of the global IP landscape. We extend our sincere thanks to all contributors who have shared their knowledge and perspectives. We are equally grateful to our readers and partners for your continued engagement and support. We hope this edition provides valuable insight and encourages ongoing dialogue across the global IP community. Thank you for your continued support and readership. Management team. Northons Media PR and Marketing Limited. Published by Northons Media PR and Marketing Limited. Carlos Northon. CEO and founder, Northons Media PR and Marketing Limited, publisher of the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Carlos at northonsprmarketing.com. Dhruva Dakani. Director of Creative Design and Global Marketing for the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Dhruva at northonsprmarketing.com. Hitanshi Gohil. Senior Graphic Designer and Researcher for the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Hitanshi at northonsprmarketing.com. Bhumika Goswami. Sales Account Manager for the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Bhumika at northonsprmarketing.com. Kushraj Singh Jowli. Senior Reporter for the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Newsdesk at northonsprmarketing.com. Zafira Hudani. Reporter for Northons Media PR and Marketing Limited for the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Zafira at northonsprmarketing.com. Disha Panchal. Junior Creative Design for the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Info at northonsprmarketing.com. Disclaimer: all images in the articles are provided by the authors, unsplash.com, pixabay.com, pexels.com, canva.com, freepik.com and vecteezy.com. Page 4. Editorial Board of Directors. Mladen Vukma, Attorney at Law, EU Trademarks and Patent Agent at Vukma Attorneys at Law, Croatia. Keisha Fleming Lake, Managing Partner at Severi Mon Suarez, Anguilla. Laura Collada, Managing Partner, Dumont, Mexico. Max Montero, Partner, Johansson and Langlois, Chile. Ray Zhao, LL.M. Senior Partner, Head of the International Trademark Team at Unitlin Attorneys at Law, China. Sarah Norka Anku, Global Managing Partner, S.N., Anku IP Law Firm, Ghana. Page 5. Contents page. Page 9. Hybrid Intelligence, Moving from AI-Assisted to AI-Architected IP Portfolios. Written by Dr. Shweta Singh, Founder and CEO of Ennoble IP, India. Page 13. AI, Originality, and IP Reform in Central and South America. Written by Zafira Hudani, Reporter for Northons Media PR and Marketing Limited, United Kingdom. Page 15. Till Death Do Us Part, The Effect of Death on Trademarks. Written by Michelle S. Katz, Founding Partner at Advitum IP, LLC, USA. Page 17. Non-use cancellation actions in Russia, recent practices and the malicious interest concept. Written by Anna Degtyaryeva, lawyer at Gorodisky and Partners, Russia. Page 21. Sense and Sensibility, The Future of Olfactory Marks in India. Written by Himanshu Sharma, partner at Hans Partners IP LLP, India. Page 25. The Role of IP Rights in the Sports Sector. Written by Anomi Wanigasekara, Senior Partner, and Sabira Sharif, Partner, of Julius and Creasy, Sri Lanka. Page 29. The Paradox of Copyright and Popular Media. Written by Kushraj Singh Jowli, Senior Reporter at Northons Media PR and Marketing Limited, United Kingdom. Page 33. From Patent Search to Strategic Insight, How Mewburn Ellis Transforms Patent Search Outputs into Scalable, Commercially Actionable Intelligence. Written by Sue Leslie, Digital Marketing Manager, and Geraint Evans, Senior IP Manager, Patworld, United Kingdom. Page 39. 5 Ways India's IP System Will Surprise Your Clients, and How to Stay Ahead. Written by Sanjay Kumar Patel, founder of Exelon IP, Patent and Trademark Attorney, India. Page 41. Strengthening IP Protection Across Eurasia, Insights from EAPO President Grigory Ivliev. Written by Alexei Vaknin, Partner and Managing Director of Vaknina and Partners, Russia, interviews Grigory Ivliev. Page 45. The Onus of Claim Mapping, a Serious Task. Co-authored, written by Bitika Sharma, Senior Partner, P.S. Manjanathan, Associate, and Rajneesh Kumar, Associate at Singh & Singh Law Firm LLP, India. Page 49. Skating on Thin Ice, Patent Renewals and the Cost of a Miss. Written by the RWS team, United Kingdom.
Page 6. Half Advertisements. Advert 1. HSM IP. With over 100 years of combined intellectual property experience, the team at HSM IP can protect brand names, logos, inventions, trade secrets, creative works and designs. Portfolio management/strategic advice. Renewals/annuities management. Clearance/availability searches. Dispute resolution/enforcement. Prosecution services. Anti-counterfeiting. Looking to protect your IP across the Caribbean? Hugh Street J. Moses, OBE Managing Partner. +1 34581574000. hmoses@hsmoffice.com. Rinyali Menon, Senior IP Manager. +1 345815746. mmenon@hsmoffice.com. www.hsmoffice.com. Advert 2. United Trademark and Patent Service. International Intellectual Property Attorneys. Your reliable partners for intellectual property matters in Pakistan, South Asia, Arabian Gulf, Middle East and Africa. Trademark, patent, design, copyright, domain name registration, litigation and enforcement law. Pakistan Office. 85, The Mall Road, Lahore 54000 Pakistan. Adjacent Radho Kronos, Hang 10 Mall Plaza Building. Telephone. +9 242 3628 5588 90, +9 242 3628 5581 284. Email, unitedtrademark@unitedtm.com. Websites www.utmps.com and www.unitedip.com.
Page 7. Contributors. The Global IP Magazine, Issue 25. Michelle S. Katz, Founding Partner at Advitum IP LLC, USA. Dr. Shweta Singh, Founder and CEO at Ennoble IP, India. Himanshu Sharma, Partner at Hans Partners IP LLP, India. Bitika Sharma, Senior Partner at Singh & Singh Law Firm LLP, India. Geraint Evans, Senior IP Manager at Patworld, UK. Sabira Sharif, Partner at Julius & Creasy, Sri Lanka. Sue Leslie, Digital Marketing Manager at Patworld, UK. Anna Degcharieva, Lawyer at Gorodisky & Partners, Russia. Rajneesh Kumar, Associate at Singh & Singh Law Firm LLP, India. P.S. Manjanathan, Associate at Singh & Singh Law Firm LLP, India. Kushraj Singh Jowli, Senior Reporter at Northlands Media PR and Marketing, UK. Alexei Vaknin, Partner and Managing Director of Vaknina and Partners, Russia. Sanjay Kumar Patel, Founder of Exelon IP, Patent and Trademark Attorney, India. Dr. Grigory Ivliev, President of the Eurasian Patent Office, EAPO. Anomi Wanigasekara, Senior Partner at Julius & Creasy, Sri Lanka. Zafira Hudani, Reporter for Northlands Media PR and Marketing, United Kingdom. Contribute to the Global IP Magazine. For those keen on contributing their expertise within the realm of intellectual property, IP, to a global audience, we cordially invite you to reach out to us at gip.magazine@northlandsprmarketing.com or via telephone at +44 0 2038130457. We eagerly anticipate the opportunity to collaborate and disseminate valuable insights within the IP industry.
Page 8. Advertisement. Ennoble IP Global IP Advisory Practice Protecting Innovation. At every meridian. At Ennoble IP, we advise innovators, enterprises and global institutions on building and defending intellectual property portfolios that endure. Led by Dr. Shweta Singh, our practice combines rigorous legal expertise with deep commercial intelligence, enabling organizations to transform ideas into protected, scalable global assets across every major jurisdiction. 151 jurisdictions covered. 25K portfolios managed. 36 plus months forward IP intelligence. Core practice areas. Patent strategy and global filings. Patent research and analytics. Trademark protection and brand strategy. IP portfolio management. Innovation and technology advisory. Sectors served. Technology, AI and ML, life sciences, semiconductors, agriculture, electronics, and communication, clean energy, academic, and research, media and entertainment and much more. We see intellectual property not as a passive asset, but as a strategic business instrument, anticipating market shifts, securing competitive position, and delivering measurable commercial returns. Dr. Shweta Singh, Founder and CEO, Ennoble IP. Website, www.ennobleip.com. Phone, +9 19958166931. Email, info@ennobleip.com.
Page 9. Ennoble IP article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Hybrid Intelligence, Moving from AI-Assisted to AI-Architected IP Portfolios. Subhead: Dr. Shweta Singh, founder and CEO of Ennoble IP, India, argues that IP is entering a new era in which AI no longer supports legal workflows, but actively architects dynamic, hybrid intelligence portfolios that align IP strategy with real-time business and competitive signals. Website: www.ennobleip.com. The conversation has shifted. For years, IP professionals debated whether AI belonged in the trademark or patent workflow at all. That debate is settled. The frontier question, the one commanding attention at every serious strategy table, is fundamentally different. Who controls the architecture? As AI moves from an assistant that answers questions to an engine that shapes decisions, the firms and counsel that understand this transition will define the next era of IP. The architecture shift. There is a quiet revolution underway in the corridors of IP practice, not loud, not disruptive in the theatrical sense, but methodical, structural, and irreversible. AI is no longer the junior associate scanning prior art databases at 2M. It is becoming the senior strategist sitting at the portfolio planning table, capable of reading market signals, modeling competitor behavior, predicting examiner objections, and recommending filing sequences months before a human team would have convened to discuss them. The distinction between AI-assisted and AI-architected portfolios is not semantic. It is the difference between a tool that helps you paint and one that co-designs the canvas. In AI-assisted environments, which represent the current standard at most progressive firms, AI accelerates human decisions. It surfaces relevant precedents faster, flags conflicts earlier, and reduces the administrative drag that has long been IP's silent productivity killer. These are meaningful gains. But they leave the intellectual architecture of a portfolio entirely in human hands. AI-architected portfolios are a different proposition. Here, machine intelligence is embedded into the strategic layer, defining coverage maps, identifying white spaces worth protecting, modeling the commercial value of protection in adjacent jurisdictions, and doing so continuously, not as a quarterly exercise, but as a living process that evolves with the business. The portfolio is no longer a document. It becomes a dynamic system, one that thinks ahead, not just reports back. Why now? The convergence moment. Three forces have collided to make this transition not just possible but urgent. The first is data maturity. AI systems trained on decades of prosecution histories, opposition outcomes, licensing disputes, and market entry patterns now possess something they lacked even 5 years ago: contextual depth. They understand not merely what happened, but probabilistic patterns in why, and those patterns translate directly into portfolio strategy. The second force is commercial pressure. Boards are asking harder questions about IP investment returns. The era of filing broadly and hoping broadly is giving way to demands for precision, for portfolios that can demonstrate commercial alignment, competitive defensibility, and monetization readiness. AI provides the analytical density to answer those questions credibly and consistently. The third force is competitive intelligence. Trademark and patent landscapes are not static environments. They are contested terrains where competitors move, pivot, and probe boundaries in real time. The firms and brand owners who can read those movements at scale, tracking filing patterns across classes and jurisdictions, identifying encroachment risks before they mature, spotting the white space a competitor is about to occupy, gain a structural advantage that compounds over time. Manual analysis, however diligent, cannot operate at this velocity. Key insight: organizations that moved to AI-assisted workflows improved clearance speed by 40 to 60%. Those moving to AI-architected models are reporting portfolio efficiency gains that reshape entire budget conversations. The hybrid intelligence model. It would be a category error to conclude that AI-architected means AI autonomous. The most sophisticated practitioners are not ceding control to machines, they are building what we should properly call hybrid intelligence systems, environments where human judgment and machine analysis are structurally integrated, each performing the functions they do best. What machines do best? Pattern recognition at scale. Machines can ingest filing histories across millions of records, identify examiner tendencies in specific classes, detect subtle shifts in competitor strategy across territories, and model the likely success rates of prosecution arguments, all simultaneously and without fatigue. In portfolio terms, this means AI can construct a coverage map that reflects both current protection and forward-looking commercial exposure in a way no human team could replicate within a realistic budget. What humans do best: judgment, ethics, and relationship intelligence. The decision to challenge a competitor's mark, to license rather than litigate, to abandon protection in a market where a commercial relationship matters more, these require contextual wisdom that sits outside any training dataset. Experienced IP counsel understand client cultures, board risk tolerances, and the reputational geometry of disputes in ways that no model, however sophisticated, presently captures. Hybrid intelligence respects this. It does not attempt to replace human judgment, it gives human judgment better information on which to operate. The practical architecture of a hybrid intelligence system in IP has three functional layers. The first is continuous intelligence, an always-on monitoring layer that tracks filings, disputes, renewals, and market developments, feeding a live portfolio health dashboard. The second is strategic modeling, AI-generated scenario analysis that presents decision-makers with ranked options and their projected outcomes across commercial, legal, and reputational dimensions. The third is execution support, AI-assisted drafting, prosecution management, and deadline intelligence that reduces the operational friction between strategic intent and legal execution. The portfolio as a living asset. One of the most profound shifts the AI-architected model enables is temporal. Traditional IP portfolios are inherently retrospective. They protect what has been built and what is currently commercialized. Review cycles are periodic. Gaps are identified after the fact. Conflicts are discovered when they have already become problems. AI-architected portfolios introduce prospective intelligence. By modeling business trajectories, new product categories, geographic expansion, brand extension strategies, AI systems can identify protection needs 12 to 36 months in advance of commercial deployment. This matters enormously. Filing timelines, examination periods, and opposition windows are not elastic. They operate on fixed legal calendars that punish late entry. The brand owner who files in a new jurisdiction 12 months before market entry holds a fundamentally different legal position from one who files 6 months after launch. Prospective intelligence converts this from a planning aspiration into an operational reality. Beyond timing, AI enables portfolio rationalization at a level of analytical rigor that has simply not been economically feasible before. identifying marks that are maintained at cost without serving a commercial function, spotting classes where protection is incomplete relative to actual use, modeling the true cost-to-value ratio of maintenance decisions across a multi-hundred-mark portfolio. These are calculations that previously required disproportionate human resources. AI performs them continuously and invisibly, surfacing recommendations for human review rather than demanding human construction. Strategic implication. Prospective AI portfolio modeling can identify protection gaps up to 36 months before commercial exposure materializes, converting reactive filing into a genuine competitive strategy. Navigating the risk. Intellectual honesty demands that the risks of this transition receive equal attention to its opportunities. They are real, and they are not trivial. The first risk is bias amplification. AI systems trained on historical data inherit the patterns of that data, including patterns of examiner inconsistency, jurisdictional idiosyncrasy, and market distortion. An AI that has learned that certain classes are routinely challenged will recommend more conservative filings in those classes, potentially underprotecting clients in commercially important areas. Human oversight must be sophisticated enough to interrogate model recommendations rather than simply accepting them. The second risk is the commoditization trap. If every firm deploys similar AI tools trained on similar datasets, the outputs will converge. The differentiation advantage of AI-architected portfolios depends on the quality and uniqueness of the data inputs, the sophistication of the models applied to those inputs, and, critically, the judgment with which human counsel interprets and extends AI recommendations. Firms that treat AI as a commodity procurement will find that it delivers commodity outcomes. The third risk is regulatory uncertainty. The question of AI-generated inventorship, AI-assisted prosecution, and the evidentiary status of AI analysis in dispute proceedings remains unsettled across most major jurisdictions. The INTA community has an important role to play in shaping these frameworks, and practitioners deploying AI-architected systems must stay actively engaged with regulatory developments rather than simply awaiting clarity. Finally, there is the governance question. Who is accountable for an AI-recommended filing strategy that produces an adverse outcome? This question requires clear protocols within firms and with clients, not because AI increases the probability of error, but because accountability frameworks must evolve alongside decision-making processes. Governance is not an obstacle to AI adoption, it is a prerequisite for sustainable AI adoption. The strategic imperative for INTA members. For the professionals gathered in London, the question is not whether to engage with this transition. The question is how quickly and how deliberately. The organizations that will define the next decade of IP practice are those currently making infrastructure decisions about data architecture, technology partnerships, talent development, and governance frameworks that will prove consequential long before their competitive implications are visible to observers. For in-house IP teams, hybrid intelligence offers the possibility of genuine strategic elevation, moving from a function that processes IP-related work to one that drives business strategy through portfolio intelligence. That elevation requires investment. Not primarily financial, but organizational. It requires IP functions to develop the analytical literacy to work with AI outputs and the strategic authority to act on them. For external counsel, it requires a fundamental reconception of where value is delivered. The efficiency gains from AI will eventually compress the fee structures associated with high-volume prosecution and clearance work. The counsel who will command premium relationships are those who deliver strategic intelligence that clients cannot access independently, who synthesize AI outputs with legal expertise, commercial understanding, and institutional knowledge into genuinely differentiated advice. For the broader INTA community, it is an opportunity to lead. The development of best practice frameworks for AI governance in IP, the advocacy for sensible regulatory approaches to AI in prosecution and dispute resolution, and the creation of professional standards that ensure AI deployment enhances rather than undermines the quality of IP protection, these are community-wide endeavors that will shape the environment in which every member operates. Looking forward, the portfolio of 2030. It is worth pausing to describe what we are building towards, because the destination clarifies the journey. The IP portfolio of 2030, for organizations that make the right infrastructure investments now, will be a continuously managed, data-rich asset that is dynamically aligned with business strategy. It will flag emerging risks automatically, recommend protection strategies in response to market signals, manage the cost-value ratio of its own composition in real time, and provide counsel with the analytical foundation to advise clients with a precision that today requires disproportionate resources. It will not be managed by AI. It will be managed by skilled IP professionals working with AI professionals whose roles have evolved from procedural executors to strategic architects, whose value lies in the judgment, creativity, and relational intelligence that machines do not replicate, and whose leverage has been multiplied by orders of magnitude by the analytical infrastructure beneath them. This is the promise of hybrid intelligence in IP, not the replacement of human expertise, but its amplification. Not the automation of strategy, but the elevation of it. The firms and practitioners who understand this distinction, and act on it, are not simply adopting new technology. They are defining what IP practice means in the generation ahead.
Page 12. Advertisement. Northons Media PR and Marketing Limited. Specialists in intellectual property publishing, media, PR and marketing. Why rely on agencies that need to learn your industry first? Your work in intellectual property is specialized, technical, and globally significant. Your marketing should reflect that, delivered by a team that understands the industry inside out. Publishing. Social media management. Brand awareness/lead generation. Webinar/conference. Event planning and management. Website development and maintenance. 20 plus years experience. 100 plus successful clients. 25K plus global distribution. 85% retention rate. Contact us today to enhance your visibility with a free consultation. Call +440 2038130457. Email info@northonsprmarketing.com. Website www.northonsprmarketing.com.
Page 13. Northons Media PR and Marketing article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: AI, Originality, and IP Reform in Central and South America. Subhead: Zafira Hudani, reporter for Northons Media PR and Marketing, United Kingdom, examines how Central and South American jurisdictions are modernizing their IP frameworks to keep pace with international standards. Website: www.northonsprmarketing.com. The protection of IP remains fundamental to safeguarding innovation and commercial value. As technological developments, particularly AI, continue to reshape how works are created and distributed, legal systems must adapt to ensure that protection remains both meaningful and enforceable. As a result of the growing challenges in enforcing IP rights and an evolving digital environment, Central and South America have seen significant developments in IP law, particularly in legislative reform and the application of the originality requirement to AI-generated works. Evolving IP frameworks in Central and South America. Jurisdictions across Central and South America are actively modernizing their IP frameworks, often in response to international agreements and the demands of digital commerce. In Guatemala, recent institutional developments, including the inauguration of a mediation center within the Intellectual Property Registry, introduced additional mechanisms for authors and creators to enforce copyright protections outside of court proceedings, reflecting a broader shift toward alternative dispute resolution in IP matters. Costa Rica has introduced a system allowing existing European Union patents to be recognized domestically, subject to payment of a validation fee at the time of application. This development may streamline patent protection and reduce procedural burdens for rights holders operating internationally. Chile has acceded to the NICE agreement, adopting the classification of goods and services for the registration of trademarks. This alignment with international standards enhances consistency and predictability for trademark applicants operating across multiple jurisdictions. Argentina has entered into a new trade agreement with the US, under which it has committed to strengthening domestic regulation and enforcement of IP rights, particularly in the digital commerce space, aligning the country with international standards. El Salvador has consolidated its IP legislation under the newly created Salvadoran Institute of Intellectual Property, providing a unified framework for protecting patents, trade names, emblems, expressions, or signals of commercial advertising, geographical indications, appellations of origin, trade secrets, utility models, and industrial designs. This framework introduces a new section of the law, Intellectual Property in Digital Environments, to address domain-related disputes, including cybersquatting and distinctive sign disputes. These developments form part of a reciprocal trade agreement with the United States concluded in January of this year. In 2024, Venezuela introduced initiatives aimed at strengthening national cybersecurity infrastructure, including the creation of a National Cybersecurity Council. While not specific to intellectual property, such developments contribute to the broader digital enforcement environment in which IP rights are increasingly exercised. The originality requirement and AI-generated works. The emergence of AI-generated content has brought renewed attention to the originality requirement in copyright law, with authorities in the region reaffirming the centrality of human authorship. In Peru, attempts to obtain copyright protection for AI-generated works prompted the Copyright Office of INTA to clarify that authorship must be attributed to a natural person and that the work must meet established originality requirements. The Colombian Copyright Office has emphasized the requirement of the intellectual expression of a natural person, while Brazil requires the author/inventor to be a natural person, rejecting AI-generated works or inventions. However, AI-assisted works are permitted if the human is the primary creator. Taken together, these developments suggest a consistent regional approach reflective of an international standpoint. Notwithstanding rapid advances in generative technologies, copyright protection remains grounded in human creativity. Enforcement challenges in the digital environment. While legislative frameworks are evolving, enforcement of IP rights, particularly in online environments, remains complex. Trademarks are particularly vulnerable in digital marketplaces. The diversity of legal systems across the region, combined with differing procedural and substantive requirements, can complicate enforcement efforts, especially where infringing activity spans multiple jurisdictions. Common forms of online infringement include the sale of counterfeit goods, cybersquatting, and domain name disputes. A notable example arose from Brazil, where the first business court of the São Paulo Court of Justice found that the retailer Mercado Libre had used the trademark Veríger, which belonged to a well-known security company with the same name, in a manner likely to cause consumer confusion. This case illustrates how trademark misuse can occur through sponsored advertising practices, highlighting the evolving nature of infringement in platform-based commerce. Conclusion. The developments outlined above demonstrate that jurisdictions across Central and South America are actively adapting their IP regimes to address the challenges posed by digitalization and AI. Legislative reform, institutional innovation, and judicial clarification, particularly in relation to originality and online infringement, indicate a growing readiness to respond to emerging risks. However, the effectiveness of these frameworks will depend on consistent enforcement and continued responsiveness to technological change. For IP professionals, the region presents a dynamic and evolving landscape, requiring close attention to jurisdiction-specific developments within an increasingly interconnected legal environment. Page 15. Advitum IP article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Till Death Do Us Part, The Effect of Death on Trademarks. Subhead: Michelle S. Katz, founding partner at Advitum IP, LLC, USA, examines how trademarks are treated as valuable estate assets and explores the legal mechanisms for transferring these rights after an owner's death. Website: www.advitumip.com. Trademark assignments are not unusual. Marks are routinely transferred in connection with business sales, mergers, corporate restructuring, and settlements. In each of those situations, ownership changes during the lifetime of the owner. But what happens when ownership must transfer because the owner has passed away? When a trademark owner dies, their IP becomes part of their estate. If the owner left a will, the mark passes according to the terms of that will, subject to applicable probate law. If there is no will, the mark passes under the state's intestacy statutes. Importantly, a will does not automatically update the United States Patent and Trademark Office (USPTO) records. Instead, it grants the executor, or personal representative, the legal authority to transfer ownership to the beneficiary. The estate must formally effectuate and record the transfer with the USPTO. The process of assigning a trademark through an estate typically involves several steps: identifying all registrations and applications, confirming registration status, executing a written assignment document from the estate to the beneficiary, and recording the assignment with the relevant trademark office. Ownership rights pass upon completion of estate administration, not automatically at the time of death. There are specific requirements for the transfer of ownership rights upon the owner's death. The assignment must clearly identify the marks, the associated goods and services, and confirm the transfer of goodwill. Documentation must include the legal instrument effecting the transfer, typically a will, trust certification, or executor's deed of distribution. The USPTO requires submission of an application to record ownership change using Form TM Assignment. Jeffrey Scatoff, How to Inherit a Trademark, Scatoff, PA, June 3, 2025. The estate's personal representative should also prepare legal documents to establish the chain of title, including the assignment agreement and evidence of authority, such as letters testamentary. ID. Finally, beneficiaries or their legal counsel must file the required trademark assignment documents to formally update ownership records. ID. Celebrity chef Anthony Bourdain offers a compelling example of trademark transfer through an estate. Over the course of his career, Bourdain built a powerful personal brand through books, television, publishing, and public appearances. Over time, his name itself served as a commercial identifier for media protection, publishing, speaking engagements, and branded ventures. Bourdain's trademark profile is a meaningful asset to his brand and legacy, and therefore, was protected in his will. Following his death in 2018, Bourdain left all of his assets to his daughter, Ariane Bourdain, who was 11 at the time of his death. Because she was a minor at the time, the assets were placed into a trust, with his ex-wife, Ottavia Bourdain, serving as trustee. ID. A review of Bourdain's USPTO records shows that the marks were formally assigned pursuant to estate administration. Interestingly, in the supporting documents it states that Bourdain's will did not provide for a specific bequest of his intellectual property, Anthony Bourdain, registration number 4509637. Instead, Article 4 of his will simply state that all property comprising the residuary estate of Anthony M. Bourdain passes to his issue, per stirpes, subject to the trust provisions of Article 5 of the will. ID. This language demonstrates an important point. A will need not list each trademark individually to effectuate transfer, particularly where the entire residuary estate is devised to a single beneficiary. Not all IP, however, is owned by individuals. Many public figures and business owners hold their trademarks through corporations or limited liability companies. For example, popular singer Sabrina Carpenter's trademark portfolio is owned by Bumblebee Holdings, LLC. U.S. Trademark Application Serial Number 98/551512, filed May 15, 2024. Because an entity owns the marks, her death would not automatically trigger a trademark assignment through probate. Instead, ownership would remain with the company. This structure often provides continuity and administrative efficiency. A more recent example involves former One Direction member Liam Payne, who tragically died in 2024. Payne's USPTO registration still lists him as the owner. Payne's estate has filed affidavits declaring continued use and excusable non-use where applicable, as well as incontestability. Liam Payne registration number 5815739. In those filings, the attorneys listed the current owner as Liam Payne and the proposed owner as the estate of Liam Payne. ID. This suggests that a formal assignment may soon be recorded in the public record to reflect the estate's ownership. A trademark is more than a registration number on the USPTO's website. It's a legacy that embodies reputation, creativity, and the goodwill built over a lifetime. Like any other valuable asset, it doesn't disappear at death. It passes deliberately and lawfully through the hands of those entrusted to carry it forward. As Anthony Bourdain's estate illustrates, even broad residuary language in a will can effectively transfer IP when supported by proper administration and recorded assignments. The lesson is simple but powerful: estate planning is brand protection. While a life may end, a brand does not have to. Acknowledgement is extended to Sophie Gerfinkel, law clerk, for her valuable assistance in conducting research for this article. Page 17. Gorodisky article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Non-use cancellation actions in Russia, recent practices and the malicious interest concept. Subhead: Anna Degtyaryeva, lawyer at Gorodisky and Partners, Russia, examines how Russian courts are responding to bad faith non-use cancellation actions by developing the concept of malicious interest to better protect well-known trademarks. www.gorodisky.com. A changing background. In recent years, the practical landscape of trademark protection in Russia has faced unique challenges. Since 2022, geopolitical shifts have affected the presence of foreign businesses on the Russian market, with a number of international companies reducing or suspending their activities. These developments spurred certain market participants seeking to take advantage of the situation. A number of entities attempted to obtain rights to well-known international brands and benefit from their reputation. Acting in bad faith, such entities file trademark applications reproducing or closely imitating existing brands. These filings are rarely successful at the examination stage, as they are typically blocked by earlier rights. However, rather than abandoning their efforts, applicants initiate non-use cancellation actions against prior trademarks in order to remove the obstacles and register a similar or identical mark in their name. It should be noted that the statutory grace period for non-use of a trademark in Russia is 3 years. Following the suspension of business activities by a number of foreign companies starting from 2022 onwards, many trademarks are currently becoming formally vulnerable to non-use cancellation. This leads to lawsuits, a significant part of which appears to have been filed by brand squatters or even former local distributors acting in bad faith. General approach to non-use in Russia. The mechanism for early termination of trademark protection on the grounds of non-use is set out in Article 1486 of the Civil Code. Any interested person presuming the trademark has not been in use during the consecutive 3 years may initiate a cancellation action. The claimant must prove a legitimate interest in the cancellation action, or the claim will be dismissed. Evidence of interest typically shows an intention to use a similar mark supported by preparatory steps. At the same time, the rules applied to the defendants are more stringent. They must prove actual, not sham, use for each particular category of goods or services with respect to which the claimant has demonstrated interest. The principle of homogeneity is generally not applicable. The only exclusion articulated by the Supreme Court of Russia refers to widely known trademarks. If a trademark is proven to be widely known for specific categories, for which the defendant proves the use, its protection should also be maintained for the homogeneous goods. This concept is well established in judicial practice and frequently applied in cases involving renowned brands. Traditionally, this framework has been applied in a relatively formal manner. However, recent cases demonstrate that this approach is evolving. Malicious interest concept. The increasing exploitation of non-use cancellation actions as a tool for acquiring famous brands has posed a challenge to the formal approach. While bad faith entities are often able to formally prove their interest with documents demonstrating preparations for market entry, a closer examination may reveal that such preparations are directed toward the appropriation of an existing brand's reputation. In this context, the Russian IP court has begun to apply the concept of malicious interest, also referred to as sham or abstract. While not expressly defined in law, this concept is rooted in the general prohibition of abuse of rights and reflects a shift from a purely formal assessment of interest to a more substantive evaluation of the nature and purpose of such interest. The essence of the malicious interest concept lies in the recognition that interest in cancellation may not be considered lawful if it is primarily motivated by the desire to exploit the reputation of a well-known trademark. In such circumstances, the court may take into account the overall behavior of the claimant, the choice of a particular mark, and the underlying commercial rationale. One of the court cases illustrating this approach involves a Hong Kong-based company, Multigoods Production Limited, that sought cancellation of a number of Victoria's Secret marks in relation to certain categories of goods and services, Court Case No. CIP 803, 2024. The company filed an application for the mark, Figure 1, closely resembling a famous brand for a wide range of products and provided evidence of preparation to use it. Multigoods argued that the original marks, although widely known in relation to lingerie, were not used for other categories of goods and services. The defendant demonstrated that the trademarks enjoyed wide recognition across a broad range of goods and services, including clothing, cosmetics, accessories, and retail services, and noted signs of abuse of rights in the claimant's actions, arguing that the purpose of filing the claim was to capitalize on the brand's reputation. The court followed the traditional approach to wide recognition, retaining protection for goods and services in respect of which the trademarks had been established as widely known, as well as for similar goods, while cancelling them for non-similar goods. However, the court further noted that, even though the claimant's evidence formally proved interest in the action, such interest with regard to retained goods is malicious and aimed at deriving commercial benefits from the reputation of the famous brand. The court made reference to the defendant's arguments on abuse of rights, but mainly based its conclusions on defects of the claimant's interest. With the rise in actions against famous brands, courts' perspectives appear to be shifting as they subject brand squatters' claims to closer scrutiny. Recent cases involving Hugo Boss and Zanussi trademarks, case numbers SIP 1315-2024 and SIP 423-2024, demonstrate this shift. The Hugo Boss case was also filed by Multigoods, which applied for the registration of the mark, Figure 2. The lawsuit against Zanussi trademarks was filed by a local company, Stroyreesers, LLC, which previously attempted to cancel other famous brands, such as Canon and AEG. In these disputes, the Presidium of the IP Court applied a broader interpretation of the wide recognition concept and directly addressed the issue of bad faith and abuse of rights, taking into account the well-known nature of the trademarks and the absence of a convincing independent motive for their use by the claimants. The Presidium noted that if a mark is widely known to consumers, the concept of malicious interest may extend not only to similar goods, but also to goods for which consumer associations may be transferred as originating from the trademark owner. The wider the recognition of the trademark, the broader the range of goods to which such associations may extend. The Presidium stated that, for the marks enjoying long-standing recognition globally, including Russia, such a transfer of association may occur even in relation to non-similar goods. For example, while Zanussi is widely known for household appliances such as kitchen stoves, ovens, and the like, the consumers may still associate other technically complex goods, such as electronic door locks, with the original brand. Further, the courts directly established bad faith and abuse of rights in the claimant's actions, aimed at benefiting from the reputation of well-known brands and misleading consumers, and constituting unfair competition. It was also noted that the companies are free to choose their trademarks, but if their good faith is doubted, they must explain why they chose a certain mark to the court. In this context, it may appear unusual when a mentioned Russian company seeks registration of a trademark containing an Italian surname Zanussi, despite having no apparent connection to it. No explanations were provided, and the claims were dismissed. Conclusion. For owners of famous brands, these developments highlight the importance of not only maintaining evidence of genuine use, where possible, but also of demonstrating the reputation of their marks and the absence of legitimate interest on the part of the claimant. While strategies may vary case by case, arguments relating to bad faith and potential consumer confusion may serve as an effective additional line of defense for well-known trademarks.
Page 19. Advertisement. Gordiski. Intellectual Property TMT. www.gordiski.com. Page 20. Advertisement. INTA. Where intellectual property leads. The International Trademark Association, INTA, brings together the world's leading voices in trademarks and brand protection. As a trusted authority, INTA shapes policy, advances best practices, and fosters global collaboration to protect intellectual property in an increasingly complex world. Be part of the organization that helps brands navigate risk, unlock value, and lead with confidence. Become a member today. Website: www.inta.org.
Page 21. Hans Partners IP LLP article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Sense and Sensibility: The Future of Olfactory Marks in India. Subhead: Himanshu Sharma, partner at Hans Partners IP LLP, India, examines India's first accepted smell trademark application and explores how this landmark decision could reshape the legal and technological landscape for protecting scent-based innovation. Website: www.hanspartnersip.in. Recently, the Indian Trademark Office has accepted an olfactory mark for the first time in its history for an application filed by Sumitomo Rubber Industries for a floral fragrance reminiscent of roses applied to tires. This came as a welcome step in the progress of Indian IP practice, specifically in non-conventional trademark registration. Not only is this a monstrous event in the field of IP in India, but it is also a step towards modern IP concepts gaining a foothold in the Indian jurisdiction. Indian IP laws are at a stage where they are coming into their own, and, given the humongous growth of India's economy, they could become a torchbearer in the coming years. History of smell trademarks around the world. The history of smell trademarks began in 1990, when the Trademark Trial and Appeal Board, TTAB, made a landmark decision in re Celia Clark, in which it accepted a high-impact, fresh, floral fragrance reminiscent of plumeria blossoms used on sewing thread and embroidery yarn. The board established that a scent could function as a source identifier if it were not functional. In the sense of trademark law, the distinctiveness of a trademark cannot be functional in nature, it shall be distinguished from the function. In the year 1994, UKIPO accepted a strong smell of bitter beer applied to the flights of darts on the criteria that a smell mark which met the three conditions, i.e., distinctiveness, non-functionality, and graphical representation, can be registered as a trademark. Later on, in the case of Ralph Siegmann v. Deutsches Patent- und Markenamt, the European Court of Justice, ECJ, rejected a trademark which was a methyl cinnamate scent described as balsamically fruity with a slight hint of cinnamon. The ECJ was a stickler and said that a graphical representation of the mark shall be clear, self-contained, easily accessible, intelligible, durable, and objective. As a chemical formula or a subjective representation didn't meet these criteria, the mark was rejected. Smell marks in an Indian context. The Indian Trademarks Act, 1999, does not explicitly mention olfactory or scent marks. However, the definition of a mark in Section 2(1)(m) is considered broad enough to include them. Section 2(1)(m) of the Trademark Act says that a mark should include a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging or combination of colors or any combination thereof. The main problem in registration of a smell trademark in India is related to the condition provided under Section 2(1)(zb, wherein it has been mentioned that a mark which is to be registered shall be capable of representing graphically apart from the other conditions. This proved to be a hindrance to the registration of trademarks. There were many arguments against the registration of smell marks compared with sound marks. Although both are non-conventional trademarks, the factors which are in favor of registration of a sound mark are more established than the smell marks. 1. The graphical representation comparison. The graphical representation requirement is more in favor of sound over smell. Sound, unlike more subjective sensory marks, sound satisfies the requirement for graphical representation through standardized musical staves. This consistency in reproduction is why the Indian Trademark Act explicitly includes provisions for the registration of sound marks. Smell. In terms of smell marks, the laws were still not clear as to how to represent them graphically, although in the recent judgment in case of Sumitomo Rubber Industries, The Indian Trademark Office has accepted graphical representation of the smell in question, which was represented as a vector in 7-dimensional space as one of the 7 fundamental smells, namely floral, fruity, woody, nutty, pungent, sweet, and minty. The Trademark Office also said that word marks are more easily perceptible, and a large number of variations around the same word may get registered as different trademarks by different trademark proprietors. However, in the field of smell marks, a large number of variations around the smell, for instance, the smell of roses, may not be possible. Therefore, closely spaced trademarks may not get registered in the field of smell marks. However, this cannot also be the reason for refusing a trademark application. Different fields of trade and commerce may require special treatment to safeguard the interests of businesses and their customers. 2. The functionality doctrine. The Indian trademark framework precludes the registration of functional attributes to prevent a monopoly over technical necessity. This functionality doctrine dictates that a smell mark cannot be registered if it is a natural characteristic of the goods, e.g., a floral scent for actual flowers. In contrast, sound marks are rarely barred by functionality unless the specific sound is an unavoidable technical consequence of the product's function, like the hum of a motor. 3. Subjectivity versus objectivity. Voice. Human perception of a specific jingle or a celebrity's voice mark, often protected under personality rights and linked to trademarks, is relatively stable. Smell. Olfactory perception is notoriously subjective and affected by environmental factors, humidity, temperature, and individual biological differences. This makes infringement analysis much harder for smell marks. How do you prove deceptive similarity between 2 odors in a court of law without an objective standard? After evaluating these considerations, the registrar accepted the technical and legal insights offered by the amicus curiae regarding the intricate nature of the application. Specifically noting the novel approach to the graphical representation of the smell mark, the registrar has allowed the mark to proceed to advertisement in the journal. Future problems. Although this has been a watershed moment in Indian trademark law, the road ahead will not be easy to follow, given the many challenges overcome in this matter. It will not be easy for all stakeholders to pass the test of graphically and objectively representing smell, apart from other problems that depend on several factors and can only become a weapon in the hands of big enterprises to create a monopoly over a smell in reference to a particular product. The transition toward registering olfactory marks in India introduces several systemic hurdles, most notably the tech exclusivity trap, where the requirement for sophisticated 7D scientific vector modeling may create an entry barrier for SMEs lacking the resources for such specialized data. The subjectivity versus objectivity conflict compounds this, as the inherent volatility of human scent perception complicates the average consumer test and makes proving deceptive similarity an evidentiary nightmare. Furthermore, evidentiary preservation and degradation pose significant risks, as volatile organic compounds naturally break down over time, making it difficult to maintain a stable original sample for long-term enforcement. From a regulatory standpoint, the expansion of the functionality doctrine threatens to grant perpetual monopolies over scents that may have underlying therapeutic or utilitarian masking properties, which should remain in the public domain. Finally, the public search problem remains a critical gap. Unlike word or device marks, scientific scent data is not easily searchable or intelligible to the public, increasing the risk of accidental infringement by businesses unable to conduct effective clearance searches. Solutions. To address these systemic hurdles, the registry must evolve from a purely visual administrative body into a technologically integrated sensory-neutral office. Central to this transition is the codification of scientific standards within the trademark's rules, moving beyond graphical representation to include digital scent signatures or standardized gas chromatography mass spectrometry (GCMS) data as the primary record. This would solve the tech exclusivity trap by providing a clear, predictable filing path. Furthermore, establishing an AI-driven digital scent vault and a corresponding vector-based public search portal is essential to overcoming the public search problem, enabling objective clearance searches. To manage the subjectivity versus objectivity conflict and the expansion of the functionality doctrine, the registry should appoint a specialized unit of technical sensory examiners, experts capable of distinguishing between arbitrary branding scents and those that provide functional or therapeutic utility. By implementing a mandatory non-functionality affidavit and issuing certified chemical profile certificates, the registry can ensure that smell marks are as durable and enforceable as traditional word marks, effectively bridging the gap between scientific complexity and legal certainty. Conclusion. The acceptance of the Sumitomo rose-scented tires mark by the Indian Trademark Office represents a watershed moment, signaling the transition of Indian IP practice from a traditional, visually oriented regime to a modern, sensory-neutral landscape. By moving beyond the rigid constraints of the Siegmann criteria and embracing 7D scientific vector modeling, India has positioned itself as a progressive jurisdiction capable of protecting the nuanced brand identities of the 21st century. However, this monstrous event is merely the beginning of a more complex legal journey. As we have seen, the path forward is fraught with systemic hurdles, from the risk of tech exclusivity sidelining smaller enterprises to the evidentiary nightmares posed by scent degradation and subjective perception. To ensure that this breakthrough does not merely become a tool for corporate monopolies, the registry must now take the lead in codifying these scientific standards into the trademark's rules. The evolution toward an AI-driven digital scent vault and the appointment of specialized technical examiners are no longer futuristic ideals but immediate administrative necessities. Ultimately, while the registration of the first smell mark is a welcome step toward legal modernization, the true measure of its success will lie in the registry's ability to bridge the gap between scientific complexity and legal certainty, ensuring that the scent of progress remains accessible to all stakeholders in the Indian economy.
Page 24. Advertisement. INTA. 44th Annual Conference. Join us in Dublin. 17th to June 20th, 2026. Green light for growth. Dublin seamlessly blends 1,000 years of history with a vibrant spirit of creativity. INTA visitors can saunter through the gardens of Street Stephen's Green, sip cocktails in the stylish Café Insane, or browse the boutiques of Grafton Street. Hear Viking whispers in the cobbled lanes, marvel at the Book of Kells in majestic Trinity College, then savor a pint at the Guinness Storehouse. Delegates at INTA 2026 will experience firsthand why Ireland is a place where heritage meets innovation, and where bold ideas find green lights to grow. Join us in vibrant Dublin, Ireland, for a unique and unbeatable experience of green light for growth at the next INTA annual conference. Contact us, www.icta.org. INTA Secretariat, +322 513
Page 25. Julius and Creasy article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: The Role of IP Rights in the Sports Sector. Subhead: Anomi Wanagasekara, Senior Partner, and Sabira Sharif, Partner, of Julius and Creasy, Sri Lanka, examine how IP rights underpin the modern sports industry, driving its commercial growth through brand protection, innovation, broadcasting, and strategic monetization. Website: www.juliusandcreasy.com. The intersection between creations of the mind and sports is inseparable, and the discussion is far-reaching. As a result, each pillar of IP can be connected to sports. This article will briefly examine the nexus between IP and sports, focusing on different types of legal protection generally available and connected to the sports industry, as in today's context, the global sports industry is mainly driven by the commercialization of IP. According to WIPO, from football to tennis to ice skating, in every sporting field, inventors and creators are working behind the scenes to push the boundaries of athletic performance, improve audience experience, and bring sports events to every home. IP rights and the legal protection they give are the basis for key business transactions that secure the economic value of sports and push the industry forward. As reported by global management consulting firm Kearney, the global sports market is expanding, contributing to global GDP, with revenues reaching approximately $507 billion in 2025 and expected to exceed $600 billion by 2030. Trademarks, patents, industrial designs, and copyright, including broadcasting rights, are the main IP that may be linked to the sports industry. However, It is important to keep in mind that all intellectual property rights, IPR, are territorial, and the law of the relevant jurisdiction will apply. Brand protection can be considered the most valuable IP associated with any sport. Trademarks are used to differentiate, create identity, and prevent unauthorized use of brands. According to WIPO, trademarks are powerful and indispensable marketing tools. In the world of sports, their strategic use opens up significant commercial opportunities to generate income. Logos, crests, trade names of sports teams or clubs, names and marks linked to tournaments, athlete names, mascots, and iconic poses are generally protected by trademark registration. The FIFA World Cup, the Olympic symbol, and the Manchester United crest are all examples of trademarks protected in many jurisdictions. When it comes to individual athletes, CR7, the Cristiano Ronaldo brand, is protected in many jurisdictions for sportswear and fashion, and Usain Bolt's winning pose is registered as a figurative mark. These marks, whether word, motion, or figurative, are of immense commercial or merchandising value and are subject to protection against infringement, passing off, or unfair competition. Innovation is the driving force for the advancement of any sports industry. Every aspect of any sport must be examined in relation to athletic performance and advancements to receive IP protection. Manufacturers of sports apparatus, for example, could rely on patents and industrial designs. For a patent to be granted, the invention must be patentable subject matter. If the invention lacks novelty and is obvious, then it may not qualify for a patent. Also, the look and feel of particular sports equipment, such as a racket, shoes, or even clothing designs, could be protected as industrial designs, provided it is novel. For example, lighter sports equipment such as rackets and shoes, special Formula One jackets, aerodynamic gear, etc. There may be instances where, apart from patents and designs, certain information can be protected as trade secrets. Investment in research and development is essential for the growth of the sports industry, which could expand in today's context to turf management, which includes hybrid systems and even stadium design and infrastructure. Therefore, the nexus is obvious. Recordings and broadcast rights linked to sports events are protected under copyright. It's a general norm that media rights arrangements are entered into at least 2 to 3 years before a tournament. Live telecasts, promotional content, commentary, highlights, and streaming are inter alia the common segmented package of rights involved in a sports event. This could also be considered the largest revenue-generating segment, whereas the exclusive right holders also sell or sub-license their broadcasting rights to third parties. The main threat to exclusive media rights is piracy and copyright infringement. Monetization of IPR linked to sports is beneficial to the development of the industry and a competitive edge. Generally, licensing contracts are entered into for this purpose. Merchandising is one aspect. Famous sports clubs and players license their marks to manufacturers. Sports organizations monetize by selling media rights to broadcasting companies. Official sponsorships also play a significant role, and brand owners pay to associate their brand with a particular event, team, or player. Also, licensing for digital platforms or current virtual environments is a new avenue of commercial exploitation, including websites, fantasy leagues, domains, esports, and NFTs. Ambush marketing could be considered an area that requires more attention as brands try to creep into major sports tournaments or events without paying official sponsorship fees. Generally, exclusive sponsors pay significantly to associate their brand with a particular team or players, which is why ambush marketing should always be discouraged. In conclusion, IP and sports are ever evolving with cutting-edge challenges. Digitalization and technological advancement have intensified numerous issues. Therefore, commercial exploitation in the sports industry through IP and the integrity of sports must be balanced.
Page 27. Advertisement. 2026 AIPLA Spring Meeting. The future of IP in an AI-driven world, opportunities and safeguards. Join over 500 IP professionals from around the world for 3 days of networking and education. Register by April 15th to get up to $250 off registration. Fairmont, San Francisco, May 13th to 15, 2026. www www.aipla.org/events. Page 28. Advertisement. AIPF Association of Intellectual Property Firms. 2026 Annual Meeting. The Evolution of the IP Boutique, Keeping IT Niche. September 30th and October 1st, 2026. Doubletree by Hilton Toronto, downtown Toronto, Canada. Register today. More information at website www.aipf.com/2026 Annual Meeting. Email admin@aipf.com.
Page 29. Northons Media PR and Marketing Limited article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: The Paradox of Copyright and Popular Media. Subhead: Kushraj Singh Jowli, senior reporter at Northons Media PR and Marketing Limited, UK, explores how AI is reshaping copyright in popular media, creating a legal paradox where creation is cheaper than ever, but ownership has never been more contested. Website: www.northonsprmarketing.com. George R.R. Martin, J.K. Rowling, and John Grisham are authors famed for their literary works. The common link among them, beyond fame, is that each of them has been involved, to varying degrees, in protecting or litigating their IP. The intersection of AI and copyright in popular media is a fascinating mishmash. This inevitable collision between 18th-century legal jargon and 21st-century neural networks leaves the creative community in a virtual legal limbo. While technology is advancing at an exponential pace, courts are still brushing dust from the shelves of precedent. The input versus output conflict. The biggest legal knot is the distinction between the input AI uses to learn and the content it generates. AI models are trained on massive datasets of copyrighted books, movies, and art. Developers argue this is fair use, a legal doctrine that allows limited use of copyrighted material without permission from the rights holder, similar to a human artist visiting a museum to study artistic techniques. But this is an ongoing contestation in courts. Conversely, if an AI program uses this information to generate an image of a bespectacled boy with dark hair and a wand in hand that looks strikingly similar to Harry Potter, it may constitute a derivative work, a creation based upon one or more prior works. The paradox here is that whilst the AI does not copy the depiction pixel by pixel, the result can still qualify as copyright infringement, which occurs when protected elements of a work are used without permission. The authorship question. In the US, copyright law requires human authorship, meaning only works created by humans, not machines, are protected. For example, a creator may spend 50 hours refining a complex prompt to create a stunning digital masterpiece, but the US Copyright Office generally maintains that no copyright claim subsists for the resulting media if it is purely AI-generated and sufficient human contribution is found lacking. It may only allow limited ownership upon satisfaction of the human creative control, which is assessed upon the merits of each individual case. In the UK, in contrast, copyright for computer-generated works is recognized even without a traditional human author of the expression, but it still assigns authorship to a human, the organizer/operator. Consequently, popular media companies may be hesitant to use purely AI-generated assets, given the uncertainty about the extent of legal protection that may be awarded to them, increasing the risk of unauthorized use by competitors or pirates upon release. The aesthetic loophole. Copyright law protects specific expressions of presenting ideas, but not style, which refers to the general manner or approach of an artist. So, while Martin may protect elements like the Iron Throne with IP rights, he cannot copyright the concept of a regal seat welded in swords and spears. Creators are apprehensive because AI can mimic a living artist's style with exceptional accuracy, and it is not inherently unlawful for an AI model to generate works in an artist's approach, provided it doesn't replicate protected expression or the output isn't substantially similar to the original material, but flooding the market with works in their signature style can virtually replace an artist. This has sparked the no AI movement on platforms like ArtStation and DeviantArt. The Hollywood standoff. The recent strikes by the Writers Guild of America and the Screen Actors Guild American Federation of Television and Radio Artists highlighted the current dilemma for performers, the digital twin reservation. A voice artist might be paid for just one day of work, but their AI twin can star in sequels for eternity without them ever having to step on set, and without systematic compensation through royalties. So, while AI may not be credited as a scriptwriter in union-governed jurisdictions legally, artists in other countries are concerned that studios can use it to polish a human script and save themselves millions in residuals at the expense of human salaries. We are thus moving into an age where creation is cheap, but ownership is incredibly costly. The paradox of AI in popular media is that the very tools designed to democratize creativity may imperil a landscape where only the largest corporations, equipped with legal teams to navigate these gray areas, can safely produce and protect content. This tug-of-war between authors and AI companies has escalated into a defining legal conflict for the creative industry. By 2026, a number of prominent authors have joined forces, arguing that AI isn't simply learning from them, it's practically ingesting their life's work to create a competitor. Authors Guild v. OpenAI. In one of the most significant legal actions in literary history, veteran novelists George R.R. Martin, John Grisham, Jodi Picoult, and George Saunders joined a class action lawsuit led by the Authors Guild against OpenAI. The accusation: it was argued that OpenAI blanket copied the plaintiff's works, without permission or compensation, to train its large language models, LLMs. The contention of derivation: Martin is particularly concerned about fan fiction marring the flow of narrative. Fans have attempted to use AI to complete The Winds of Winter, the unreleased but highly anticipated installment in the Game of Thrones novel series, which has been pending publication for nearly 15 years. This, Martin's legal team contests, is a gross and blatant infringement of his right to control the narrative arc of his copyrighted universe. The piracy loop: evidence surfaced that some early models of major AI platforms were allegedly trained on shadow libraries such as Library Genesis, LibGen, and zLibrary, which contain large collections of pirated copies of a significant portion of the works by the author's party to the suit. Adding to the ambiguity of the current landscape is the capricious nature of precedents. The comic book case, Zarya of the Dawn, 5, the U.S. Copyright Office granted, then partially revoked, copyright for this comic. They ruled that the text and layout, human arranged, were protected, but the individual AI images, generated by Midjourney, were not. The art case, Theatre d'Opera Spatial, an AI-generated image that won a state fair, was denied copyright entirely because the human input was deemed insufficient. For established wordsmiths and filmmakers, and their dyed-in-the-wool fans, the outcome of these cases determines whether new Harry Potter-like stories or the unreleased Winds of Winter tales can be legally sold by anyone with a prompt, or whether they remain the exclusive property of the estates. For budding creators, the outcome determines the sustainability of their livelihood. Global perspectives: the Indian AI copyright scene. India has emerged as a major battleground, owing to its massive creative output and distinct copyright laws. Current judicial stance. Training AI. Courts are considering evolving the concept of fair use. It's transformative to turn a book into mathematical representations. Outputting. Courts are increasingly likely to scrutinize outputs for substantial similarity, which may give rise to infringement claims.
Page 31. Advertisement. 2026 IPO Annual Meeting. Website: www.ipo.org/m2026. September 27 to 29, 2026. Sheraton Hotel, Toronto, Canada. 30 education sessions, CLE credit, networking, expo hall, fun run/walk and more. Page 32. Advertisement. PatWorld. Research services trusted, reliable, accurate. The PatWorld team combines scientific expertise with commercial insights to deliver comprehensive IP research solutions. Our services. Partner with a team trusted by tech companies, universities, and IP professionals worldwide. Freedom to operate searches. Patentability assessments. Validity analysis. Competitor and technology tracking. Start your next search today. Mail at patworld.com. Now available, our Introduction to Patent Searching online course has now been fully updated and released. Visit our site to explore the course and start learning today. Get in touch. Innovation House, 6 Cedar Court, Celtic Springs, Newport, South Wales, United Kingdom NP 108FY. Call +44 0 16338166601. Website www.patworld.com.
Page 33. Patworld article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: From Patent Search to Strategic Insight: How Mewburn Ellis Transforms Patent Search Outputs into Scalable, Commercially Actionable Intelligence. Subhead: Patent searches are a critical foundation for identifying third-party rights, but their real value lies in how those results are interpreted and applied. Sue Leslie and Geraint Evans from Patworld explore how Mewburn Ellis transforms structured search outputs into strategic, decision-ready insights that support clients in navigating complex technology landscapes. Website: www.patworld.com. From Data to Decisions: Redefining the Role of Patent Searching. In complex and fast-moving technology sectors, identifying relevant patents is only part of the challenge. The real value lies in understanding what those patents mean and how they should influence commercial and technical decision-making. At Mewburn Ellis, patent search outputs from specialist partner Patworld are used as the foundation for a deeper analytical process. Through structured interpretation, technical expertise, and commercial awareness, these datasets are transformed into practical advice with widespread use cases, supporting freedom-to-operate assessments at all stages, product development, and investment cases. The Mewburn Ellis team are especially adept at scaling their approach to handle large-scale projects in crowded technical areas, distilling large volumes of documents into targeted, clear FTO insights. Rather than treating search outputs as a standalone deliverable, the team integrates them into a broader workflow that connects data, analysis, and strategy. This approach reflects a wider shift within the IP profession. With access to data and information easier than ever, drawing insights becomes more challenging and more important. Starting with the right question. Clients often approach us with the question, "Do we have freedom to operate?" However, as Dan Thornton, partner at Mewburn Ellis, explains, the simplicity of that question can be misleading. Clients often arrive with a very simple question, but the reality is much more complex. You need to understand what they're really asking and what they need to do with the answer, whatever it may be. Sometimes, the client is seeking early-stage funding to develop the product, and a potential investor has, for the first time, raised the idea that a competitor might have relevant IP. Here, the key concern might be to understand the IP surrounding the aspects of the product the client considers most innovative and whether it does, in fact, differentiate them from what their competitors are working on. Other times, the client is preparing to launch their product into the market, so a thorough understanding of third-party rights and how and when they could be enforced can mean the difference between a smooth launch and a business-threatening injunction. Each scenario will involve searching and analyzing patents and applications. In many cases, it pays to understand not only the immediate issue, but also how a business is expected to develop. With that understanding, the analysis can be structured to maximize future value cost-effectively, avoiding unnecessary repetition. Paul Dunn, partner at Mewburn Ellis, highlights a common misconception. A lot of clients assume that having their own patents means they have freedom to operate. But patents don't give you the right to use something, they give you the right to stop others. In many cases, clients focus on the unique selling point, USP, the feature they believe differentiates it in the market. But relevant patent rights are rarely confined to that feature. Relevance to the wider proposal may arise from supporting technologies, manufacturing processes, integration points, or peripheral components. A true freedom to operate analysis would investigate all these aspects to provide a complete picture of risk. But this completist attitude must be tempered by costs, timelines, and attitude to risk. During product development, it's often appropriate to focus on searching around the USP. This can provide valuable business intelligence, helping a company understand whether its idea is truly a USP and what its competitors are up to. By focusing, clients can avoid spending time and money reviewing rights on aspects of the project that haven't been finalized. An inappropriately completist approach can obscure the issues where a difference can be made. A can't see the wood for the trees problem. Stopping short of the completist approach is easy to say, but sometimes difficult to do. It's certainly easier with an appreciation of the baseline risks associated with a commercial proposition, which can help frame both how to identify and present additional risk introduced by a USP. This backdrop is invariably helpful, such as when talking to investors and senior stakeholders. For example, the USP might be a remote monitoring system for a medical device. With an understanding of the patent landscape for the device platform that is hosting the remote monitoring, the risks associated with the remote monitoring USP can be contextualized. Planning the analysis. Once the scope is defined, high-quality search outputs developed in collaboration with PatWorld provide the starting point. For Mewburn Ellis, the key step is what happens next. Rather than reviewing results in isolation, the team transforms search outputs into structured datasets that can be interrogated and analyzed. Rather than simply classifying individual documents by their potential risks/subject matter, the team, during their analysis, organizes the results to identify patterns, creating a framework that allows meaningful conclusions to be drawn from the dataset. As William Hay, associate at Mewburn Ellis, explains, it's not just about the number of documents you find, or even how relevant an individual hit is. By thinking strategically about how you're going to structure your analysis, you can get a lot of additional insights that can provide valuable commercial intelligence. The Mewburn Ellis team goes beyond document review to generate broader insights. Datasets can be revisited and refined in the future, providing a foundation for ongoing work rather than treating them as one-off exercises. Understanding the landscape. In all searches, the results will include more and less relevant results. A subject matter breakdown helps prioritize and focus next steps on the areas that matter most. Different people might have different priorities, and it pays to understand where these might reside. Naturally, the dataset can be digested within and across dimensions of information, some bibliographic and some substantive. The breakdown provides different prioritization for different people. Identifying clusters of innovation is simple. And understanding where competitors are focusing their efforts. Patent rights come at a cost, so where are rights holders expending their time and money? For example, do you want to see active noise cancellation-related rights filed in 2022 by applicant A because they launched their flagship ANC-enabled product in January 2023? Simple. This is a high-level view that can inform strategic direction, particularly in early-stage development or when evaluating alternative technical approaches. In combination with other data segmentations, the breakdowns can be customized, for example, for different audiences. Would-be investors are interested in different things from research scientists. With the right foresight when analyzing, the dataset can ultimately support many different stakeholders. It's all too easy to fall back on these projects as an academic exercise in claim scope and dates. This is often the comfort zone for patent attorneys after all. However, we know that the game-changing value results from putting these analyses in the context of the industry sector and the client's business aims. Dan Thornton, partner at Mewburn Ellis, explains, "The questions I ask myself are how many people can I support with this dataset? Who might care about what we are doing here? We want to give business owners, R&D directors, research scientists, investors, patent attorneys, my colleagues, and my future self useful output from this dataset. Adding depth through feature-level analysis. For some interested parties, the detail matters. These are often technical people who understand and need the technical specifics to inform their work. With detail comes the risk of becoming overwhelmed. It's imperative to provide focus and prioritization. Naturally, the all-important context is again used. For example, there might well be a broad right on the acoustic driver in the headphone space. But the stage of the patent process, other rights and prior art in the dataset or otherwise known, earlier products and methods, and the applicant, for example, inform what that particular right really means and how it should be approached. By examining the specific features described and claimed in patents, Mewburn-Ellis can identify dominant technical approaches, how different solutions compare, where innovation is concentrated and where opportunities may remain. This level of analysis is particularly valuable in complex technologies, where multiple approaches may exist to achieve the same outcome. The dataset gives a broad picture of the sector, with examples within. With the overview and the detail, we can have those technical conversations, specific rights, in context. This allows the team to move beyond simply identifying problems and towards navigating the landscape and delivering value within it, focusing efforts where they matter and not where they don't. A critical distinction: claimed vs described. Claimed features at least represent what the applicant thought was clever. Those features are considered to represent something worth the spend to seek patent protection. Unclaimed details, by contrast, can provide insight into the applicant's broader technical direction and serve as a useful source of prior art for downstream work. For example, the medical technology landscape has a focus on digital health innovations, where now standard heart rate monitor technology is found more often only in the description as part of a supporting platform. Can we then use the dataset as a historical record of those standard features in the field as they move from the focus of innovation to the support on which innovation is built? Often, yes. Particularly for clients moving into a new space, how subject matter has moved through applications with time can be highly informative. Here we begin to separate legal risk from sector-level intelligence. Applying insight to downstream work. There is a spectrum of work available to clients when it comes to third-party rights. At the old-fashioned end is the largely academic exercise of hit-by-hit right review, current state of the claims, jurisdictional coverage, dates, options for attack, and relevance to product. For Mewburn-Ellis, the structured datasets that we develop with our clients enable a more useful approach to these analyses. Rather than reviewing large volumes of documents in isolation, the team can prioritize the most relevant material and concentrate on genuinely critical issues. These genuinely critical issues then provide the focus for further efforts. One such effort is an active attack on problematic rights, clearing the way. In Europe, patents can be challenged both before grant, by third-party observations, and after grant, with EPO oppositions and UPC invalidity proceedings. Inevitably, attacking a patent involves finding and understanding prior art, and knowing how and when to deploy this. A carefully organized third-party rights dataset can be very useful in this respect. In the most straightforward sense, the dataset holds prior art that might be relevant. Team members have also reviewed the dataset, they have a feel for what's in there and what's not. Their insights can be critical in framing further targeted prior art searching. With temporal analysis of how a sector has developed, informed stakeholder conversations are possible. Where is the strongest prior art, and has the examiner spotted it? And, in the general context of the sector, how challenging is this case likely to be? A scalable, collaborative model. Delivering this level of insight requires a coordinated, team approach. At Mewburn-Ellis, this includes those who work closely with clients, defining strategy, setting bounds, and gathering context. Associates often conduct detailed technical and legal analysis with trainees supporting dataset development and categorization. Often, we include data processing specialists to enable efficient and repeatable processing of datasets. Fran Salisbury, partner at Mewburn-Ellis, highlights how this approach is particularly important in specific fields. In life sciences, you're often assessing risk long before the product is fully defined. The analysis needs to reflect where the project is in its life cycle. The ability to scale analysis from focused projects to large, multi-thousand document datasets is critical. By distributing work appropriately across the team, Mewburn-Ellis can maintain both efficiency and depth. Within this model, PatWorld operates as an extension of the team, contributing specialist search expertise that aligns with how the results will ultimately be used. The newest member of the team, AI. Mewburn-Ellis is at the forefront of how AI can support us in responsibly providing our clients with improved work product. What's possible now is very different from 1 year ago, and no doubt very different indeed from what will be achievable in the next few years. Third-party rights analysis is no different in this respect. AI has its shortcomings for now. There are clearly areas that are unsuitable, or where the checking required would be so deep that the tools currently provide no tangible benefit. That said, there are spaces where AI can already be leveraged to prioritize and help to summarize, for example, leaving our people to focus on the aspects of the work that add the most value. More importantly, at this stage across Mewburn Ellis, we can all access AI tools, often for client work and, if not, for other non-client projects. Everyone in the existing teams is building the confidence to use AI tools responsibly. When the time comes to exercise those skills on their specialisms, they will be ready. Thank you to contributors, Dan Thornton, Fran Salisbury, William Hay, and Paul Dunn of Mewburn Ellis. About Mewburn Ellis. Mewburn Ellis is a leading European IP firm working with innovative companies across engineering, chemistry, and life sciences. The firm combines technical expertise with strategic insight to help clients protect, manage, and maximize the value of their IP assets throughout the innovation lifecycle. To learn more, visit www.mewburn.com or get in touch with the team to discuss how they can support your IP strategy. Working with PatWorld. At PatWorld, searches are tailored to the specific needs of each firm and project. Whether supporting broad landscape analysis, highly targeted prior art searches, or structured datasets prepared for detailed analysis, outputs are designed to align with client methodologies. For firms such as Mewburn Ellis, this ensures that search results are not only comprehensive but delivered in a format that supports downstream analysis, enabling more efficient, scalable, and high-quality third-party rights assessments that evolve alongside client needs. To learn more about how PatWorld supports firms with tailored patent searching and data-led analysis, visit www.patworld.com or get in touch with the team.
Page 38. Advertisement. Northens Media PR and Marketing Limited presents the IP360 Hub, the global industry profile guide connecting the global IP community. IP360 Hub connects IP professionals, law firms, and service providers through an affordable print and digital interactive networking platform, where the IP world connects effortlessly. Profiles, service and rates listing, advertisement, printed handbook and interactive digital platform. Launching in early 2027. IP lawyers, counsel, service providers, advisors, industry partners. Website, www.ip360hub.com. Email, info@ip360hub.com. Telephone, +44 0 2038130457.
Page 39. Exelon IP article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: 5 Ways India's IP System Will Surprise Your Clients, and How to Stay Ahead. Subhead: Sanjay Kumar Patel, founder of Exelon IP, patent and trademark attorney, India, argues that India must be treated as a primary IP jurisdiction in its own right, warning that imported assumptions can quietly erode IP protection. Website: www.exelonip.com. India is no longer a secondary consideration in global IP strategy. With patent grants exceeding 100,000 in a single year, a judiciary producing precedents with international resonance, and a 1.4 billion person consumer market, it demands jurisdiction-specific advice, not a scaled-down version of what works elsewhere. The most expensive mistakes International Council makes in India rarely involve missed deadlines. They arise from applying assumptions built in other systems to a jurisdiction that operates on fundamentally different principles. Here are 5 of those assumptions and what they actually cost. 1. Section 3(k) The shifting ground beneath tech patents. Most International Council know that Section 3(k) of the Patents Act, 1970, excludes mathematical methods, business methods, computer programs per se, and algorithms from patentability. What they consistently underestimate is how unpredictably this exclusion is applied, and how rapidly the ground is shifting. The Indian Patent Office historically applied a blunt instrument. Any claim with computational logic risked a Section 3(k) objection. Courts are now pushing back with precision. In Comviva Technologies v. Assistant Controller, 2024, the Delhi High Court held that mere involvement of a business activity does not render an invention a business method. The decisive test is whether the invention provides a technical solution to a technical problem. In Google vs. Controller, 2024, a patent for managing instant messaging across devices was granted after the court identified genuine technical advancement beyond the commercial purpose. In April 2025, the IPO released new draft CRI guidelines introducing structured three-step tests for Section 3(k) exclusions and explicitly recognizing AI, blockchain, and quantum computing as potentially patentable domains. 2. The copyright design dichotomy, the Section 15 trap. Section 15(2) of the Copyright Act, 1957, extinguishes copyright protection for any design capable of registration under the Designs Act, 2000, once industrially applied to more than 50 articles. The provision is widely known. Its operational consequence is not. The assumption that a copyright failure under Section 15(2) triggers automatic Design Act protection was formally dismantled by the Supreme Court in Cryogas Equipment v. Knox India, 2025 INSC 483. The court established a mandatory twin test: first, whether the work qualifies as a registrable design; second, whether its dominant purpose is aesthetic or functional. A purely functional work, one whose visual form is dictated entirely by its utilitarian purpose, fails both statutes. It falls into a protection vacuum that no amount of registration strategy can retroactively cure. For International Council managing portfolios covering physical products, packaging, consumer goods, or industrial components manufactured in India, this judgment creates an immediate audit obligation. Any product already in mass production without a design registration may be entirely unprotected if copyright has lapsed under Section 15(2). 3. Section 3(d). The reach beyond pharma. Section 3(d) is well mapped in pharmaceutical prosecution following Novartis v. Union of India, 2013. What remains poorly understood internationally is its expanding application beyond pharmaceuticals. The 2024 Nippon Steel decision confirmed that Section 3(d) reaches industrial processes. Patent office examiners are now raising Section 3(d) objections against chemical, agrochemical, and materials science applications, rejecting claims for new polymorphs, formulations, and process variants that have sailed through USPTO, EPO, or JPO examination without any equivalent objection. The trap is invisible at the portfolio level. A client holding granted patents across 30 jurisdictions assumes equivalent Indian protection, unaware that its Indian application carries an unresponded Section 3(d) rejection. The response strategy that succeeded at the EPO is largely irrelevant here. Section 3(d) requires India-specific evidential arguments, and they must be prepared by counsel who understands the provision's unique statutory architecture, which has no equivalent in any other patent system in the world. 4. Well-known trademark status, the highest return action most brands skip. India's Trademarks Act, 1999, provides formal well-known trademark status under Sections 11(6), 11(9). Once declared, a mark receives cross-class protection and is listed on the official register, acting as a perpetual, prospective bar against all future conflicting applications without requiring the rights holder to file individual oppositions. A significant number of globally prominent brands have not pursued this status in India. They fight the same opposition battles repeatedly across classes they never anticipated needing to defend, paying per proceeding costs that a single well-known declaration would have preempted entirely. The evidentiary threshold, requiring proof of use, recognition, and prior enforcement in India, is substantial but achievable for established international marks. For a brand that genuinely qualifies, this is among the highest return IP actions available in India. It is also consistently the most underutilized. 5. Honest concurrent use. Why delay becomes your competitor's advantage. Section 12 of the Trademarks Act permits honest concurrent use, and Indian courts and the registry apply it with considerably more generosity than most foreign counsel expect. A party that has built genuine, sustained local goodwill under a mark can obtain a concurrent registration even after a foreign brand holds a prior registration, provided the registry is satisfied there is no real likelihood of public confusion in practice. The implication is counterintuitive to counsel from first-to-file systems. An Indian registration obtained without corresponding commercial presence, active monitoring, and prompt opposition filing gradually degrades in exclusivity. A local user who builds goodwill during that window acquires a legitimate concurrent claim that a clean registration alone cannot defeat. The Toshiba v. Toshiba litigation, resolved after nearly 5 decades, is the most vivid illustration of what this dynamic produces at scale. India rewards commercial presence and active enforcement. It does not preserve paper rights indefinitely. A single lesson across 5 issues. Each of these 5 issues is invisible to a competent global IP practice that has not specifically engaged with Indian law. The reason they catch International Council off guard is not complexity, it is familiarity. A practice built on deep expertise in the USPTO, EPO, or UKIPO develops instincts that are genuinely wrong in India. Not wrong because the lawyers are less capable. Wrong because the system they are navigating has different bones. India does not penalize ignorance dramatically in one moment. It penalizes it gradually, a registration that erodes, a patent that gets opposed, an injunction that goes unenforced. By the time the loss is visible, it is usually irreversible. Treating India as a primary jurisdiction, with its own filing logic, its own enforcement culture, and its own statutory traps, is not about adding complexity to a global portfolio. It is about not paying twice for the same work. Contact details: Sanjay at excelionip.com. Page 41. Vaknina and Partners article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Strengthening IP Protection Across Eurasia. Insights from EAPO President Grigory Ivliev. Subhead: Alexei Vaknin, partner and managing director of Vaknina and Partners, interviews Grigory Ivliev about recent trends in Eurasian patenting, the growing role of the pharmaceutical register, and the future digital and cooperative development of the EAPO. Website: www.vaknina.au. Note: the Eurasian Patent Organization is an international intergovernmental organization founded in 1994 in accordance with the Eurasian Patent Convention, EAPC. The World Intellectual Property Organization and its Director General, Dr. Arpad Bogsh, significantly contributed to the drafting of the EAPC. The Eurasian Patent Organization brings together 8 countries: Azerbaijan, Armenia, Belarus, Kazakhstan, Kyrgyzstan, Russia, Tajikistan, and Turkmenistan. The Eurasian Patent Office is the executive body that administers the regional system for the legal protection of inventions and industrial designs based on a single Eurasian patent. Grigory Ivliev is the president of the Eurasian Patent Office. The Eurasian Patent for Invention is valid from its granting date in the territory of all 8 member states. Only 1 application in Russian and 1 set of fees are required, with no additional validations and translations into national languages. Companies have the opportunity to significantly reduce financial, timing, and organizational expenses and obtain protection that covers the entire region. Users from more than 130 countries highly estimated the Eurasian patent system's advantages. It is possible to keep the Eurasian patent for the invention in force selectively, just in the territory of those countries where you need it. This requires payment of annual fees for the designated countries. The Eurasian Patent for Industrial Design is valid throughout the entire territory. A considerable number of EAPO applications are PCT applications, which have entered the regional phase. Since July 1, 2022, the Eurasian Patent Office has functioned as an international searching authority and an international preliminary examining authority under the PCT. Dr. Ivliev, how would you assess the state of Eurasian patenting in 2025? In 2025, users of the Eurasian patent system demonstrated several positive trends in their activity. The number of invention applications increased by 12% in comparison with 2024. The largest number of Eurasian patent applications were traditionally filed for inventions related to pharmaceuticals, biotechnology, fine organic chemistry, and medical technology. On average, 83% of Eurasian patents remain in force, and the most notable growth in activity is shown among right holders from China, Russia, and the United States. The Eurasian patent system remains attractive to applicants from both the Eurasian region and third countries, largely due to the region's strong trade and economic integration. In addition, the Eurasian Patent Office has consistently maintained high-quality standards. We apply leading international practices in the examination of inventions and strictly adhere to our international obligations to all applicants without exception. I firmly believe that the IP field must remain within the framework of the rule of law and be free from any kind of politically motivated discriminatory measures. Our mission is to encourage and incentivize creative people so they can move this world towards a better, more sustainable future. The unilateral illegitimate measures implemented by the European Union, which deny Russian applicants the protection, maintenance, and enforcement of their IP rights, not only undermine the fundamental principles of international IP treaties, such as the principle of national treatment, but also create dangerous precedents and legal uncertainty. What is the EAPO doing to strengthen enforcement? One of our key priorities is developing the Eurasian Pharmaceutical Register. The register contains structured and verified information on invention patents protecting pharmacologically active substances that have been assigned international non-proprietary names, INNS. The data contained in the register is publicly available and can be used to prevent the entry of generic products into the market where rights to the original medicine remain in force. It includes both Eurasian and national patents of the EAPO member states, added at the request of the rights holders. Demand for the Eurasian Pharmaceutical Register is growing. Extracts from the Pharmaceutical Register are used in the consideration of disputes related to patent infringement. In 2025, the register expanded to include additional Eurasian and national patents, increasing by 16%. A specialized module was developed to identify patents related to active pharmaceutical ingredients, APIs, specifically chemical compounds and biotechnological molecules. It indicates the items of a claim that protect such ingredients, as well as the full invention claims, while separately highlighting the structural characteristics of the API. It is important to note that in 2025, the EAPO introduced a mechanism for information exchange with organizations interested in the automatic verification of the register data, for example, in the context of public procurement. We hope this practice will continue to expand, providing rights holders with an additional resource for enforcing their rights. What trends are you seeing in IP disputes in Eurasian states? IP disputes tend to rise globally as IP becomes increasingly valuable. A Eurasian patent for an invention or industrial design may be invalidated in the territory of a member state in full or in part. Since 2023, EAPO representatives have participated in any litigations relating to the validity of a Eurasian patent as a third party. More than half of the disputes considered in the member states were focused on organic chemistry and pharmaceutical inventions. From 2023 to 2025, there were disputes over 35 Eurasian pharmaceutical patents in the Russian Federation, the Republic of Belarus, and the Republic of Kazakhstan. 2 of 35 patents were invalidated in full in the Russian Federation, and 3 were invalidated in part. 1 patent was invalidated in the Republic of Kazakhstan. What recent developments have taken place in the Eurasian system for the protection of industrial designs? Eurasian industrial design protection retains all the advantages provided for inventions, a single procedure and a single patent granted. Application requirements are optimized as much as possible. An application may include up to 100 designs related to one class of the International Classification of Industrial Designs. The industrial designs included in one application are not subject to the unity of design requirement. Since the beginning of 2025, the scope of the Eurasian patent for industrial designs has been extended to Turkmenistan. The entry into force of the Protocol on the Protection of Industrial Designs to the Eurasian Patent Convention for Turkmenistan has opened up new opportunities for system users, creating further prospects for EAPO integration into the Hague system for the international registration of industrial designs. This step was already approved by the EAPO member states, and in 2026, the Eurasian Patent Office will begin accepting international registrations. Let us move on from the results of the past year. Looking ahead, how do you envision the future Eurasian Patent Office? I may not be giving an original answer here, but the Patent Office of the future is undoubtedly a highly digitalized one. The Eurasian Patent Office is also striving to keep pace by developing advanced information systems to make its electronic services as convenient as possible for both applicants and examiners, meeting their needs. Key developments included projects related to the creation of the EAPO Integrated Information System, taking into account users' requests, legislative changes, and existing trends in technology development. We are already testing systems that incorporate artificial intelligence technologies. These tools will be used for patent classification, similarity searches for inventions and industrial designs, machine translation, the distribution of examiners' workloads, and user support. We understand that this is an essential prerequisite for maintaining the quality of our work under current conditions. Another cornerstone for the future successful work is human resources. EAPO is proud of the multinational, diverse team representing all member states. In 2023, we launched a fellowship program to enhance representation and expand the number of young examiners. Women are well represented in leadership positions and make up a larger share of employees than men. Last year, member states supported our initiative to create the Examiners Working Group to discuss a range of challenging topics. The working group will serve as a new platform for exchanging best practices among examiners at the Eurasian Patent Office and at national offices in patent search and examination. The professional network ensures a comprehensive approach to human capital development and enhances the quality of IP solutions across Eurasia. Does this Eurasian Patent Network contribute to the harmonization of examination practices? Yes, I think it does. It contributes significantly to the common patent examination and information space development. The aim is to ensure the highest possible level of harmonization in the granting of patent protection. We are implementing a number of projects related to cooperation in the fields of invention search and examination. They include agreements on patent search and preparation of patentability reports by EAPO examiners at the request of national offices, EAPPH, to reduce duplication of patent search and examination work, patent information exchange, and many other initiatives. What are the benefits for the applicants? I believe the harmonization initiatives contribute to legal certainty and building trust. The first international IP conventions were developed in the 1880s, and they are still in force. The conservative IP system with its territorial nature of IP rights contradicts the contemporary economy, cross-border trade, and global value chains. The international and regional patent cooperation projects help to reduce costs for both offices and applicants. Generally speaking, regional tools help reduce trade and economic barriers arising from the territorial nature of IP rights. The Eurasian Common Patent Space is especially relevant because 5 of the 8 EAPO countries, Armenia, Belarus, Kazakhstan, Kyrgyzstan, Russia, are members of the Eurasian Economic Union, which has its 4 freedoms space. The Eurasian system is the most appropriate option for those who need protection in several countries at once. Some of the ambitious objectives include expanding the Eurasian system to include the Eurasian trademark and utility model. We believe that new types of Eurasian IP will be a valuable tool for companies operating in the region. Dr. Ivliev, thank you very much for your detailed and informative interview. I would like to wish the Eurasian Patent Office further professional growth and development, an increase in the number of participating countries, and growth in the number of applications filed and patents registered. Patent and trademark attorneys of Vaknina and Partners will be pleased to assist you and your clients with any questions or inquiries regarding IP matters in the EAPO, Russia, Armenia, and other Eurasian countries. Our specialists in Moscow, Russia, IP@vaknina.ru, Yerevan, Armenia, office@vaknina.am, and Bishkek, Kyrgyzstan, kilogram@vaknina.com, are ready to provide more information regarding your request. Dr. Grigory Ivliev is the EAPO president. The Eurasian Patent Office, EAPO, is an executive body of the Eurasian Patent Organization, administering the regional patent registration system covering 8 countries in the Eurasian region. Member states: Armenia, Azerbaijan, Belarus, Kazakhstan, Kyrgyzstan, Russia, Tajikistan, and Turkmenistan. Objects for IP rights protection, inventions and industrial designs. Dr. Alexey Vaknin is partner and managing director of Vaknina and Partners. He is a Eurasian patent attorney and a patent and trademark attorney of the Russian Federation, with extensive IP experience since the 1990s. Vaknin is a member of the Eurasian Patent Attorneys Assembly, EPAA, FICPI, AIPPI, LESI, INTA, ECTA, PTMG, etc. With a PhD in medicine, biochemistry and immunology, while working on patent matters, Vaknin specializes in medicine, biotechnology, biochemistry, and pharmacology.
Page 44. Advertisement. Women's IP World Podcast. Celebrating the work and achievements of women in IP law and innovation globally. Explore an empowering podcast series highlighting the extraordinary contributions and milestones of women shaping the landscape of intellectual property and global innovation. Website: www.womensipworld.com. Hosted by Michelle S. Katz from Advitum IP, LLC, Chicago, USA.
Page 45. Singh & Singh Law Firm LLP article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: The Onus of Claim Mapping, a Serious Task. Subhead: Bitika Sharma, Senior Partner, P.S. Manjanathan, Associate, and Rajneesh Kumar, Associate, of Singh & Singh Law Firm LLP, India, examine how India's evolving patent litigation framework, anchored in rigorous claim mapping, is reshaping infringement actions. Website: www.singhandsingh.com. Abstract. In the framework of patent enforcement, claim mapping serves as the foundational element of patent infringement litigations. For practitioners navigating the complexities of global patent regimes, it is evident that the precise delineation of a right holder's territory determines the scope of legal protection. In patent litigation, this territory is determined by the technical language of the claims. A patentee shows breach of the granted patent's territory through the concept of claim mapping. While jurisdictions such as the United States have long mandated high standards of pre-filing technical analysis, the Indian patent regime has recently undergone a significant transformation, codifying rigorous standards to ensure that patent litigation serves to protect innovation, rather than facilitating the abuse of monopoly rights. This article explores the evolution of claim mapping in India, analyses the requirements of the same, and explores how the same could be performed in the absence of the infringing product being available. The conceptual divide: technical rigor versus consumer perception. To appreciate the application and importance of claim mapping in patent law, it is essential to distinguish patents from other forms of IP, especially trademarks. The key difference lies in how the scope of protection is defined and analyzed in different IP regimes. A patent claim delineates the exact boundaries of an invention, functioning as a picket fence around the technology, such that patent monopoly is determined by the precise wording of the claim, and infringement arises only when each and every element or its substantial equivalent is present in the infringing product. This requirement necessitates a detailed, element-by-element analysis, which is known as claim mapping. In contrast, trademark infringement analysis focuses on the impression a mark creates on the mind of the average consumer and requires only the likelihood of confusion, rather than a detailed, element-by-element comparison. The global standard: comparative insights from the United States and Europe. The U.S. approach to patent infringement provides a structured two-step framework that has influenced and shaped global standards. The process begins with claim construction, the legal interpretation of the meaning of claim language, followed by a technical comparison of those construed claims to the accused product. At the pre-suit stage, Rule 11 of the Federal Rules of Civil Procedure requires attorneys to certify that their factual contentions are supported by evidence after a reasonable inquiry. In the patent context, This obligation is fulfilled through the Rule 11 claim chart, a pre-filing necessity where a complainant maps each limitation of every asserted claim to corresponding features of the accused product. Failure to conduct this level of technical inquiry can lead to severe sanctions or even dismissal of the suit. The claim charts have a long history in U.S. litigation. One example case in which a claim chart was referred is Twindisk, Incorporated v. the United States. U.S. jurisprudence reinforces the all elements rule, which holds that infringement occurs only if the accused product contains each element literally or at least an equivalent for each limitation of the claim. The absence of any of the essential elements precludes literal infringement. This high threshold ensures fair notice to the public and prevents patentees from using broad or vague claims to capture non-infringing technology. Similarly, European patent litigation emphasizes claim construction based on the description and drawings, guided by the Protocol on the Interpretation of Article 69 EPC. One of the earliest European cases on patent infringement, Rodi and Weinberger AGV. Showall, Henry, Limited, confirmed that to succeed, the patentee must show that all essential elements of the claim are present in the alleged infringing invention. European courts adopt a balanced approach between literal and purposive construction, often applying the doctrine of equivalence to cover alternative solutions that achieve the same technical effect. However, the application of either literal infringement or the doctrine of equivalence is informed by the result of the claim mapping. The genesis and evolution of claim mapping in India. Historically, Indian patent suits followed, and still follow, the standard procedures of the Code of Civil Procedure, 1908, where the standard of pleadings was not patent-specific. However, the technical complexity of modern sectors exposed the limitations in the general standard of pleadings. Accordingly, India's patent regime shifted toward a rigorous claim mapping requirement amid rapidly evolving science and technology. A key catalyst for this transition was the Commercial Courts Act, 2015, enacted for the speedy disposal of complex disputes in commercial suits. The judiciary further advanced this cause through the adoption of claim mapping in the case of F. Hoffman La Roche Limited v. Cipla Limited. Building on this foundation, the Honorable High Court of Delhi notified the High Court of Delhi Rules Governing Patent Suits, 2022. The defining provision is Rule 3(a)(9), which mandates that every plaint in an infringement action must include a precise claims versus product, or process, chart mapping to the extent possible. This codification transformed claim mapping from an optional best practice into a mandatory procedural requirement. Rule 3(a)(9) enforces precision in pleadings, requiring the plaintiff to substantiate its technical case at the time instituting the suit. This shift curbs the earlier practice of initiating a vague infringement suit to secure an ad interim/interim injunction, with technical substation deferred to a later stage. By mandating mapping at the outset, the 2022 rules ensure that courts evaluate the prima facie case on the basis of concrete technical or circumstantial evidence rather than broad and unverified allegations. Judicial scrutiny and the litmus test in Indian courts. Indian courts, particularly the Honorable Delhi High Court, have recently adopted a granular approach to mapping, focusing on the litmus test, provided during the patent prosecution stage. In Mold Tech Packaging Limited v. Tetra Pak India Private Limited, the judiciary reinforced the principle that if essential features of the claim are missing or substantially different in the accused product, a prima facie case of infringement cannot be established. This mirrors the U.S. all elements rule, asserting that a word means nothing outside the claim. Building upon these foundations, a recent division bench decision in Zydus Lifesciences Limited v.e. R. Squibb & Sons LLC addressed the failure to undertake proper claim mapping in a high-stakes biosimilar dispute. The Humble Court held that treating a product as infringing merely because it is a biosimilar is fundamentally flawed, emphasizing that infringement must be assessed on a product-to-claim mapping, as regulatory biosimilarity does not lead to patent infringement. Where the allegedly infringing product is not available in the market, the patentee remains obligated to undertake such mapping on the basis of circumstantial or inferential evidence. The decision also reflects the increasing reliance on prosecution history estoppel, in India, to impart clarity in mapping and preventing a patent owner from asserting infringement beyond the claimed scope defined during prosecution, especially in a quia-timit action. However, the Humble Court has not exemplified any circumstantial evidence for the purpose of establishing infringement in a quia-timit action. In view of the above, claim mappings in infringement suits are therefore indispensable, forming the core of any effective patent litigation strategy to secure protection over any innovation in India. Thus, a successful patent enforcement action in India cannot be won on procedural gambits but on the substantive strength of the case presented from day one. The indispensability of mapping in quia-timit actions and circumstantial evidence. The requirement for claim mapping becomes critical in quia-timit actions, where lawsuits are filed in anticipation of future infringement when the defendant's product is not yet commercially available. Under Section 48 of the Patents Act, 1970, which grants patentees an exclusive right to prevent others from making or selling that product, the court now requires a technically certain basis to conclude that the impending product, in fact, is falling under the claimed scope. While Rule 3(a)(9) uses the qualifier to the extent possible, this does not permit conjectures and assumptions. In such cases, a plaintiff is required to adduce overwhelming circumstantial material, which may include product specifications, regulatory filings, blueprints, CAD drawings, marketing and promotional material specifying the product, patent specification filed by defendant, supplier orders for specific components, production or process records, the product laboratory data, technical disclosures in public, drug approval dossiers, environmental filings, safety certifications, biosimilar or generic submissions that describe the process/composition, press releases, product brochures, inventor presentations, trader shows, technical conferences, simulations or modeling based in specifications that demonstrates the product's/process's identity with each features of the claim, as assumptions cannot replace rigorous element-wise comparison. Although SQIB provides clarity to a patentee's obligations in instituting infringement suits, it is a recent pronouncement, and its applicability remains to be seen. Conclusion. The transition to a structured claim mapping regime in India has profound practical consequences for all parties. Patentees now bear a significant pre-filing evidentiary burden, requiring detailed technical analysis through mapping to demonstrate the accused product's identity with claimed elements. For the patentees, this framework enables more efficient case management. By requiring mapping at the threshold, the judges can quickly proceed to decide ad interims with more clarity. The defendants can now challenge incomplete or flawed mappings to resist ad interim/interim injunctions. The introduction of Rule 3(a)(9) has proved to be a game-changer, reflecting India's move toward a mature and streamlined patent enforcement framework, which also aligns with the procedural standards of global practices. The said rule ensures that patent enforcement rests on technical certainty rather than broad legal assertions, thereby safeguarding both innovation and public interest.
Page 48. Advertisement. Women's IP World Ranking 2027. Top 100 Influential Women Leaders in IP Law, Champions of Leadership, Innovation, and Global Influence 2027 Ranking. Subscribe now to receive exclusive updates. Be the first to know when nominations open for the 2027 Women's IP World Ranking. Celebrating the women's achievements and excellence across the international IP community. Brought to you by Northens Media PR and Marketing Limited. Call +44 0 2038130457. Email wipw@northonsprmarketing.com. Website womensipworld.com.
Page 49. RWS article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Skating on Thin Ice, Patent Renewals and the Cost of a Miss. Subhead: RWS explores how rising costs, complex global rules, and the risk of simple administrative errors are putting patent renewals under pressure and what businesses can do to protect the value of their IP portfolios. Website: www.aws.com. Patent renewals under pressure. Patents play a critical role in innovation. From wireless communications and medical breakthroughs to new ways of enjoying media content, they help innovators protect expensive research and development. They can also contribute significantly to business value. Once patent rights are obtained, proper lifecycle management becomes crucial to protecting those interests. Renewals are central to effective patent lifecycle management. Preserving a patent means preserving the exclusive rights granted to the inventor and maintaining control over how an invention is used, licensed, or commercialized. Those rights often result from substantial financial and intellectual investment. Keeping them in force allows the patent holder to protect that investment, prevent unauthorized use, and continue to capitalize on market opportunities. An active patent can support competitive advantage, attract investors, and generate revenue through licensing or partnerships. Missed renewal deadlines put all of that at risk. A lapse can jeopardize market position, trigger costly reinstatement efforts, or lead to irreversible loss of protection. That significance becomes sharper in a global market, where patents are often maintained across multiple jurisdictions at once. A portfolio may include rights tied directly to products, licensing strategies, or future business plans. Maintaining those rights demands consistency, organization, and a clear understanding of how renewal obligations vary from country to country. The consequences of missed renewals. The loss of a patent through a missed renewal can be abrupt, and the consequences severe. One recent example involved the patent rights connected to the Froster ice resurfacing machines used on Ottawa's Rideau Canal Skateway. The machine was developed out of necessity. The Rideau Canal Skateway in Ottawa, Canada, is the world's largest skating rink, and maintaining such a large surface required a solution capable of handling that scale. The inventors produced a uniquely engineered machine tailored to the task. Despite the significance of the invention, the patent lapsed because an email notification from the Canadian Patent Office went into a junk mail folder and was not seen. The case is striking because the failure was so ordinary. The invention addressed a real operational problem and produced a distinctive technical solution. Yet the legal protection attached to that invention still depended on a routine maintenance obligation being met at the right time. A missed notification was enough to cause the rights to lapse. The history of the telephone offers a much older illustration. Although the telephone is usually associated with Alexander Graham Bell, Antonio Meucci has also been formally recognized for his contribution to the invention. Historical accounts commonly note that Meucci was unable to maintain his patent caveat, weakening his position as Bell's product went on to commercial success. These examples underline the importance of renewal discipline. Patent rights can protect inventions of clear commercial and technical significance, yet those rights remain dependent on the patent holder's ability to satisfy continuing maintenance requirements. A more complex environment for global portfolios. The challenge grows as portfolios expand across borders. With the global scale of business today, managing multiple renewals on a single patent asset across several jurisdictions quickly becomes cumbersome. The complexity is not simply a matter of more deadlines. The rules themselves vary, and they do so in ways that affect both administration and budget planning. Most patent offices around the world charge annual renewal payments, often called annuities, starting a few years after filing or grant. The timing, however, varies by jurisdiction. In India, fees become due from the second anniversary of the filing date, meaning year 3, and any pre-grant fees that have built up must be paid on grant. In Europe, annuities are payable to the European Patent Office while the application is still pending, beginning in the 3rd year from filing. Australia follows a similar model, but from the 4th anniversary. In Brazil, annuities are also payable during prosecution and are calculated from the 2nd anniversary of the filing date. China is different again, with the first annuity due only once the patent has been granted. The United States follows a different model. Rather than annual payments, the U.S. Patent and Trademark Office, USPTO, charges maintenance fees at 3.5, 7.5, and 11.5 years after grant. Several countries, including Japan and South Korea, include additional renewal charges depending on the number of claims per patent. Some countries also offer renewal fee discounts based on factors such as entity size, entity status, or residency. In the US, reduced rates are available for qualifying small and micro entities. Managing a portfolio across several jurisdictions means working with a mix of filing date-based obligations, grant-based obligations, annual annuities, staged maintenance fees, and local rules on claim-based charges or discounts. Rising costs and portfolio decisions. The cost environment adds another layer of pressure. Since 2022, several major patenting jurisdictions have changed renewal payments. Those changes have practical consequences for businesses that maintain substantial patent portfolios across more than one country. They also sharpen the need to understand which assets remain commercially important. Renewal fees generally increase over time, so later payments in a patent's life are often higher than earlier ones. The effect is to make long-term portfolio maintenance a financial question as well as an administrative one. As patents mature, businesses are required to make more deliberate decisions about which rights are worth preserving and which no longer justify the cost. That makes it important for executive staff to understand which assets are critical to product commercialization. Regular review of commercial value is therefore closely connected to renewal practice. Product sales and licensing revenues are identified as key metrics in determining a patent's value. Competitor products in the same sector may also provide useful information, either by revealing possible business partners looking to acquire patent rights or by pointing to potential infringers who can be ordered to take a license. Communication between IP professionals and business dealmakers inside the company can reveal which patent assets may be attractive to corporate partners or venture capital investors. The question of whether to renew a patent is not answered by deadline tracking alone. It also depends on whether the asset continues to contribute value, directly or indirectly, to the business. Quarterly assessments of the commercial value of an IP portfolio can help teams make decisions more quickly on which patents to renew or maintain. In jurisdictions where renewal costs increase based on claim count, identifying individual claims for abandonment can also offer future savings. Timing still matters. Even with a strong review process, timely payment remains one of the clearest ways to minimize cost and reduce risk. Patent owners typically have a window in which renewal payments can be made before the official deadline. This window can range from 3 to 6 months, depending on the country. In the US, patent owners have a window of 6 months before the due date to pay a maintenance fee. In the UK, the window for annuity payments begins 3 months before the due date. When those payment windows are missed, grace periods are often available, but at additional cost. In Japan, patent owners who miss an annuity due date have an additional 6 months to make payment, but amounts paid during this period are charged at double the annuity rate. In the US, patent owners can make late maintenance payments within a 6-month grace period. If that period is also missed, they may be able to petition for acceptance of an unintentionally delayed payment after expiration, subject to USPTO requirements and petition fees. Late payment mechanisms can preserve rights in some circumstances, but they do so at a price. For businesses managing a large number of patents, those additional costs can accumulate quickly. Why renewal fees exist? Renewal obligations also sit within the broader economics of the patent system itself. Patent offices are governmentally authorized agencies, but they typically operate like business units funded outside the normal appropriations process. The USPTO and the European Patent Office, EPO, are both entirely funded by fees collected from patent applicants and other stakeholders. That funding structure supports very large operations. The USPTO expects operating expenses of $4.68 billion in fiscal year 2026, while the EPO's 2023 budget reached €2.57 billion. More than half of the USPTO's annual operating budget is spent on its examiner corps, most of which is employed on the patent side. An annual performance report for fiscal year 2023 showed that the USPTO employed 8,568 patent examiners at year-end. Those figures help explain why renewal fees remain such a central part of the patent landscape. They are part of the financial structure that supports examination and patent office operations on a large scale. Centralization and cost control. Given the complexity of global renewals, many businesses look for ways to centralize management and reduce risk. Working with a third-party renewals management provider can help improve efficiency and reduce exposure to missed deadlines. Centralization can also ease the burden of tracking patent assets and related data across multiple jurisdictions. Cost control is another reason to look closely at renewal management arrangements. Taking time during regular audits to review a solution provider's service fees can identify underperforming arrangements and highlight where more cost-effective options may be available. This is especially relevant where renewal activity is being handled across a large portfolio and service fees form a significant part of the overall spend. Choosing the right renewals partner. Managing global patent renewals is complex, and choosing the right partner can make a significant difference. Renewal management providers may engage different agent networks around the world, which makes global coverage supported by local expertise an important consideration. A provider with a robust network of vetted agents can help ensure compliance with local regulations and timely payments worldwide. Payment frameworks also matter. Reliable providers are able to ensure timely payments, often without upfront remittance, giving clients financial flexibility while keeping deadlines under control. Direct payment capabilities with certain patent offices can reduce reliance on third-party agents and reduce overall costs, although this is dependent on local regulations. Quality controls are another important part of the picture. Data verification processes using official patent office data sources, together with internal quality controls, can identify discrepancies that many businesses miss when they handle renewals themselves. Indemnity insurance can provide a safety net against rare but serious risks such as accidental lapses. RWS provides lifecycle solutions for patent management needs, including patent renewal services designed to support the management of patent assets across jurisdictions. Page 52. The Global IP Magazine. Service listing. Listing 1. Heidi Kawand, founder and CEO, AIP Genius. Reluctant to use AI in IP? With AIP Genius, don't be. Our vertical AI ecosystem combines AI speed with human-in-the-loop precision. Our IP-specific AI agents automate the workflow, searching to filing and renewals, with verification ensuring valid outputs. IP isn't a guessing game. AIP is just genius. Website: www.aipgenius.com. Listing 2. Amit Aswal, Managing Partner, Anov IP. Anov IP is a global IP strategy and solutions firm with specialized divisions Anov IP Asia, Anov IP Analytics, Anov IP AI, Anov IP Universities, Anov IP India, and Anov IP Advisory, helping organizations create, manage, and monetize intellectual property through expert-led, technology-enabled insight. Website: www.anovip.com. Listing 3. Hugo Silva, Managing Partner, Hugo Silva and Maldonado. Brazil is the largest country in Latin America, LA, which, with its natural resources, is internationally and economically very promising. Hugo Silva and Maldonado covers all areas of IP and business law in LA, coordinating and centralizing filings and prosecution of patents, trademarks, designs, etc. Website: www.hugosilva.com. Listing 4. Pritesh Gohal, co-founder and partner, registered patent agent, Intellect Peritus. Intellect Peritus is a globally trusted boutique IP and tech consultancy with combined 18+ years of excellence, delivering end-to-end solutions across patents, designs, and trademarks, from searches and drafting to prosecution, valuation, monetization, licensing, and PCT national phase. Website: www.intellectperitus.com. Outside back cover. Caribbean Trademark Services. Law Office of George C. J. Moore, P.A. Over 40 years of one-stop trademark services in the Caribbean. Anguilla, Antigua, and Barbuda, Aruba, Bahamas, Barbados, Belize, Bermuda, British Virgin Islands, and many more. Website: www.intellectperitus.com.
www.caribbeantrademarks.com. Telephone, USA 1-561-833-9000. Email, ip@caribbeantrademarks.com. Address, 2855 The Boulevard, Palm Beach Gardens, Florida, 33410.
You have been listening to issue 25 of the Global IP magazine. If you would like to be part of the industry's #1 IP publication to share your knowledge with the global IP community, then please reach out to us at telephone +44 0203 813 0457 or email us at gip.magazine@northansprmarketing.com. Visit our website www.globalipmagazine.com. Thank you.